So now we are going live on YouTube.
You are not audible. Hello. Am I audible?
Yes, sir, you are audible.
Yeah,
Vinas,
fine.
sir, am I audible to you? Yes, sir. So good evening to one and all present here. As we all know that yesterday we had lost one of our greatest leader, former President of India and Bharat Ratna, Shri Pranab Mukherjee. His demise is passing of an era, a colossus in public life. He served Mother India with the spirit of a sage. I request all of you to observe a 2-minute silent mourn in the memory and honor of the departed soul. Thank you very much. Someone so great can never be forgotten. May the kind soul rest in peace. A very good evening to all the dignitaries present here at the inaugural session of much awaited 1-week online workshop on intellectual property rights and entrepreneurship development, IPRED 2020 under TechIP 3, organized by the Department of Management Studies, NIT Silchar, in association with Institute Innovation Cell, NIT Silchar. On behalf of the organizing committee of this workshop, I, Dr. Saurav Verma, coordinator of this event, extends a warm welcome to our distinguished guest, Director, NIT Silchar, Professor Shivaji Bandyopadhyay, President, Institute Innovation Cell, NIT Silchar, Professor F. A. Talukdar, former Associate Director, IPR and IPR Division, DRDO, Shri Avinash Kumarji, Mr. Sandeep Agarwal, IP Attorney, Adastra IP Law Firm, Delhi, Coordinator, TechIP 3, NIT Silchar, Dr. Sukumar Pati, Head, Department of Management Studies, NIT Silchar, Dr. Ashim Kumar Das, expert speakers who have joined, various deans present here, faculty members, and my dear participants. We are immensely honored with your gracious presence. In this contemporary world where creativity and innovation have become the important drivers of the economy and the growth of a nation, the government of India has come up with its mission, that is Atmanirbhar Bharat, to make India a self-reliant nation. Entrepreneurs are those who create a holistic ecosystem, facilitating advancement and development in the field of technology in the world full of challenges and hurdles. The government of India has launched its flagship initiative, Startup India, on January 16, 2016, as to promote awareness and adoption of IPRs by the budding entrepreneurs and to facilitate them in commercializing of their particular intellectual property rights. This workshop is designed to focus on right kind of orientation to the participants in strengthening knowledge of entrepreneurship with basic understanding and practical approach to the intellectual property rights. The prime purpose of this workshop is to inspire young minds to become innovative and change makers. The technical sessions of this workshop will be led by highly qualified and eminent faculty from reputed academic and research organizations like DRDO, CSIR, NRDC, EDII, IIE, IITs, and NITs. I'm happy to share that the event has received a marvelous response from the national and international level, and a number of 1,430 participants have registered themselves for the event across the world. The participants includes academicians, research scholars, law and engineering graduates, budding entrepreneurs, and enthusiastic individuals of different startups. A number of international participants have also registered for the workshop from various countries like Mexico, UAE, and Iran. I strongly believe at the end of this workshop, the participants will have an advanced knowledge of IPRs and its importance and implications in promoting entrepreneurship and startup ecosystem. Now, I would like to request Head Department of Management Studies, Dr. Ashim Kumar Das, to address the gathering with his kind words. Please, sir.
Thank you, Shora. So, warm good evening to everyone. Respected Director, sir, respected speakers of the workshop, and other dignitaries present, and my dear participants. I, on behalf of the Department of Management Studies, NIT Silchar, welcome you all to the inaugural session of the 5-day workshop on intellectual property rights and entrepreneurship development. Entrepreneurship and innovation are considered as the engine of economic progress of a nation. Entrepreneurs are the medium through which innovation are diffused into the economy. They are the people who takes the risk of bringing those ideas or innovations into life. India has tremendous potential if it's offer an unique incubation environment to her entrepreneurs. In today's knowledge economy, entrepreneurs is the critical aspects who have the ability to make a difference. They need to be nurtured.
This call is now being recorded.
It also becomes important to give protection to their innovation and inventions. Therefore, country needs to build a ecosystem where protection of innovation through IPR regulation is the need of the hour. This will bring confidence and competitive spirit to our business in the global market trend. It will also boost our endeavor to make our nation an Atmanirbhar Bharat. Taking into consideration the importance of entrepreneurship and innovation, the workshop was conceptualized. I hope the workshop will be successful in inculcating the knowledge among the participants regarding entrepreneurship and IPR. It will be a rich experience as the workshop will be conducted and delivered by the renowned expert in their respective domain. Thank you all for being with us and enjoy the rest of the session in days to come. Thank you. Thank you once again.
Thank you very much, sir, for your kind words. Now, I would like to request Chairman IPRED 2020, Professor F.A. Talukdar, to address the delegates and valued audience. Over to you, sir.
Thank you, Dr. Saurabh Verma. Respected Professor Shivaji Bandyopadhyay, Director, that means NIT Silchar, Sri Sandeep Agarwal ji, and Patent Attorney, Sri Avinash Kumar ji, retired Associate Director of the DRDO, Dr. Sukumar Pati, the Coordinator, that means the TechIP 3, the Head of the Department, Dr. Ashim Kumar Das, the Convener of the workshop, Dr. Saurabh Verma, my distinguished colleagues, the Deans, Heads of the Department, as well as all the participants. On behalf of the Institute Innovation Cell, as well as Department of Management Studies, I welcome that Mr. Professor Bandyopadhyay in this 5 days, that means the webinar on intellectual property right and entrepreneurship development 2020. I also that means the welcome Avinash Kumar ji as well as Sandeep Agarwal ji in our that means the campus, that means the in a virtual mode. It's a wonderful campus, and if you have ever if you can that means ever get an opportunity, hopefully that means you will like it so much that means I will go on that means telling people that I need to go to that means the Silchar and NIT Silchar campus that means once in every year. It's really that means a wonderful campus, full of that means the greenery, full of that means the lakes and other things. So, in association with the Department of Management Studies, the Institution Innovation Cell, we together that means have organized that means this workshop on intellectual property right and entrepreneurship development. The pandemic has forced us to take shelter of that means the internet, even to that means to conduct our day-to-day activities, even teaching, research, business, everything is now that means moving to internet. Of course, internet was that means used to do that means e-commerce and most of the other things. But now we have, been that means forced to rely it in such a manner that lot of things are that means required to be that means put in place, and lot of that means training and other kind of things are that means required to be inculcated in the mind of that means people. And the HOD Department of Management Studies has rightly said, we are that means moving towards a knowledge economy. And once that means we move to a knowledge economy, then the most important thing is that we need to respect that means the intellectual property or intellectual ability of that means every that means fellow human being. We should not that means just live. In other words, what we can say is that we should not that means copy paste the concept of that means a fellow citizen as that means our citizen, which will be that means highly unethical. And what is very important in this situation is that we need to sensitize that means the people at every that means the spectrum, that we need to respect the intellectual ability of that means everyone else. So the one of the that means the major idea is to sensitize that means the people, okay, what we should do and what that means we should not that means do. Entrepreneurship and intellectual property right will always that means go that means hand in hand. And in the knowledge economy, that we need to do something so that it becomes that means more and more that means important in the lifestyle of that means everyone. On behalf of the organizing committee, I welcome that means all the participants in this webinar, and hope that means in future when the situation that means improve after a pandemic, then you make it a point that means to visit our campus, interact with our that means the faculty, and hopefully that means they will be enriched by the beauty and greenery of our campus and erudition and knowledge of our colleagues. Thank you all. Over to Dr. Barma.
Thank you very much, sir, for your kind words. Now, I would like to request Dr. Sukumar Pati, Coordinator TechIP 3, to share a few words with us. Please, sir, over to you.
Thank you, Dr. Verma. Good evening to one and all. Respected Professor Shivaji Bandyopadhyay, Director NIT Silchar, Professor F.A. Talukdar, Chairman of IPRED 2020 and President of Institute Innovation Cell, Dr. Osim Kumar Das, Head Management Studies, Sri Avinash Kumar and Mr. Sandeep Agarwal, distinguished experts for this workshop, my esteemed colleagues and dear participants. At the outset, I must congratulate to all the coordinators, Dr. Osim Kumar Das, Dr. Saurabh Bharma, and Dr. Ranjoy Hajra from Electronics and Instrumentation Engineering Department for their initiative and efforts to conduct this workshop. I am sure that attending this workshop is a unique opportunity to all the participants to learn the useful and relevant information about the intellectual property rights and entrepreneurship development. In this context, I am happy to share with you that the number of filing of patents as well as the grant of patents are increasing in the recent years. This shows the awareness of importance of intellectual property rights among all the stakeholders of NIT Silchar. Unlike many other institutes, all the departments of NIT Silchar are organizing online workshops during this current pandemic situation. As a coordinator TechIP 3 and IPS cell, I express my sincere gratitude to our Honorable Director Sir for his kind approval to conduct online workshop under TechIP 3 and the financial supports for filing patents under TechIP 3. Once again, congratulations to all the coordinators and all the participants. I wish a grand success of the workshop. Thank you.
Thank you very much, sir, for your kind and motivating words. On this momentous occasion, we have with us Shri Avinash Kumarji as expert speaker for the event. I request Shri Avinash Kumarji to kindly bless the delegates with their insights in the domain of IPR. Avinash, sir, over to you. Sir, kindly unmute yourself. Sir, we are unable to hear you. You have to mute. You have to unmute yourself, sir. Sir, can you rejoin again? Avinash, sir. Sir, kindly rejoin again, sir.
Now I'm audible.
Yeah. Absolutely, sir.
I'm
Yes,
so
sir.
sorry. I was trying to. Okay. Now,
Okay, sir.
I'm so sorry. Now, Honorable Professor Sivaji Bandyopadhyay, Director NIT Silchar, Mr. Sandeep Agrawal, Dr. Sukumar Pati, Coordinator TEQIP, Professor F.A. Talukdar, Chairman IPRED 2020, HOD DOMS, Dr. Saurabh Verma, distinguished participants, ladies and gentlemen. It's a matter of honor and pleasure to be a part of inaugural ceremony of the workshop on intellectual property rights and entrepreneurship being organized by NIT Silchar in the virtual world. Maybe the workshop is being organized in the virtual world, but the problem to be discussed during the workshop will belong to the real world. And look how we are responding to the challenges of corona pandemic. You see, now I never imagined that I would be joining an inaugural ceremony from the luxury of my drawing room. The thing is, the possibilities, the opportunities are being explored. How to how to keep our interaction intact uh, with the maintaining the physical distance, with maintaining the physical distance. So what I am trying to highlight that we have to look for the opportunities, every possible opportunities, and that is the hallmark of the entrepreneurship. And as far as intellectual property rights are concerned, let me tell you, the intellectual property rights with the huge flexibilities and opportunities with the patents and design, trademark, copyright, etc. This provides an opportunity to entrepreneurs to create a niche market using these tools as a marketing tool to create a niche market for themselves. And entrepreneurs with their passion and risk-taking appetite are the best people to take advantage of this. I'm sure this workshop will inspire the participants to go in that direction. And let me tell you, in the last 5 years, tremendous work has been done to create the the policy framework as well as the institutional framework. Look at how Government of India has been framing policies. Look at the Startup India program. Look at the SIPP program, the NRDC program, the TIFAC, PFC. So help is available. If anybody wants to file a patent application, then all kind of help, including financial help, is available. And look, the only thing is that entrepreneurs have to take some step, positive step, and opportunities are there. I will just quickly finish, just highlight one thing. Look at the coffee mugs. Now, the coffee mugs were over the period of time being used for taking coffee. But one entrepreneur thought, why not use the screen printing? And then see, the entire new market has been created for the coffee mug. Now it is being used as a memory carrier. So everybody will be having a lot of coffee mug, not for exactly drinking coffee, but using it as a memory carrier. So what I'm trying to highlight, the framework is there, the policies are there, And the only thing is that someone has to take advantage of all those policies. I'm sure this workshop during its proceedings will trigger some thought process, maybe among the students, to carry forward and do something tangible at the market level. And once again, I thank NIT Silchar for providing me an opportunity to be a part of inauguration ceremony. Thank you. Thank you.
Thank you very much, sir, for your motivating and inspirational words. Now, I would like to request our other eminent speaker of the day, Mr. Sandeep Agarwal. Thank you, sir. Thank you. Now, I would like to request our other eminent speaker for the day, Mr. Sandeep Agarwal, IPR attorney, to share few words with us. Mr. Sandeep, over to you, sir.
Thanks a lot, sir. I mean, many thanks to Dr. Saurabh for putting this together. And I second what Professor Fazal said regarding the beauty of the campus. I've been lucky enough to visit NIT Silchar twice and quite mesmerized by the natural beauty. So thanks a lot once again for having me there once again, though virtually this time. And I see a lot of students have actually registered for this particular workshop, and I hope this makes sense in terms of practical application of how they can actually take advantage of the IP when they eventually come to joining a business or even starting a business. I remember reading somewhere regarding Khushwant Singh. When he was a child, he failed in class 10th. So he was going to his maternal place for holidays, and he was quite gloomy and dull. So one gentleman, quite old, he was sitting in front of him. He asked, I don't understand why a 15, 16-year-old child who should be so bubbly and energetic is sitting so dull. So he said that मेरा एक साल बर्बाद हो गया, मैं 10th में fail हो गया. So he said that I have failed in class 10th and that's why I'm disappointed. The gentleman said, साल भी कभी waste होता है. I mean, how can a year be wasted? Do whatever you like. And he actually wrote this in his biography. So whatever he did after that, after this particular incident, that year he read everything what he could. He was passionate about reading, so he read everything from Shakespeare to, I mean, whatever he could lay his hands on, he read that book. And that actually took him to great strides, and we know him as one of the most prominent and eminent writers of the modern era. So the point is, there is a blessing in disguise. I hope most of you have actually made a point to utilize this particular lockdown period and the period after to really think about and do what you are passionate about. So IP is all about innovation, and in this workshop we will be talking a lot about innovation. So I hope you derive practical benefits out of these. Keep your pen paper ready, ask questions. In fact, I would suggest that you be ready with your queries. Many of you would be looking forward to starting your own business or a startup or solving a problem. In fact, be ready when you go for sit for placements. Instead of introduce yourself, you will be asked, what did you do during the lockdown of 2020? So this is going to become one of the testing parameters for your perseverance and also how you coped with this kind of pandemic. So I wish all the best for this workshop, and thanks a lot once again for having me here.
Thanks a lot, Mr. Sandeep, for joining the inaugural ceremony and for gracing the occasion. Now, I would like to take the opportunity to request Honorable Director Sir, NIT Silchar, Professor Shivaji Bandyopadhyay, to address the participants and motivate them with their 2 words of wisdom and officially declare IPRED 2020 as open. Over to you, Director Sir.
Okay. Very good evening to distinguished speakers, Mr. Avinash Kumar and Sandeep Agarwal, and my colleagues, my students and other participants to this 5-day workshop on intellectual property rights and entrepreneurship development. Now, in today's world, so simple teaching and learning process in an educational institution whether say this is a technology institution or is a science institution. Simple teaching learning does not work anymore. You need to include the research activities and you need to include the innovations as part of the regular teaching activity. Now, for the last 2.5 years, we are basically doing that. We have focused teaching research and innovation as our focus in our teaching and the learning activities, so that say whatever activities are being done by our undergraduate students, by our postgraduates or PhD students, everywhere the concept of research and the concept of innovation we are trying to inculcate in the students, because the world is changing so fast. Just going through the readings from the textbooks is not enough, and more so for a technology institute, because the technology world, the technology becomes old by the time one passes out. So but you cannot teach each and everything to the student, so that the student have to be research focused in mind, so that always the student has the capability to understand or to decipher, that is what is something that the student has to learn. Now, while we put focus on the research and the innovation, so obviously with respect to the IPR or the intellectual property rights, we have a number of workshops also initiated during the last 2.5 years or so. And we see that the different rankings, national level rankings and as well as the international level rankings that an institution is put with. So everywhere the intellectual property rights, so that has a role to play. For example, say in the NIRF ranking for engineering colleges, where we are improving our ranking year after year. And so the IPR is an important issue. We are currently ranked 46th in the NIRF ranking in the engineering colleges group. In the overall ranking category, we are placed in the 94th position. And everywhere the ranking, the IPR becomes an important component. In the innovation ranking announced by the government of India, which is known as the ATOL ranking, innovation ranking for institutions, we have been placed in the rank band of 11 to 25. So that has become possible because over the years we have put trust on the IPR issues, on the application of patents, and we have seen that is what applications might be we have done say 1 or 2 years before. So next step, they have been published. Next, they have been granted or say the awarded. So there have been say good increase in those numbers. But till now, commercialization of patents that we have not experienced, that is from patents by our own people. So that part, obviously, I think that requires some bit of say techniques also by that is what can bring a commercialization of a patent. But I think there are say that takes a time, because now with the awareness, so the number of patents granted that is increasing. Maybe with the commercialization and with the level of work that is associated with it, maybe the commercialization will come to the next level. We have made some say more significant changes with regard to the IPR activities. In the undergraduate student, in the 7th semester, we have included intellectual property rights as one of the open elective courses. That is, students from any branches of engineering, they will be able to take part the subject on IPR in this semester, which obviously we have already started in the online mode, and lot of innovative applications on the virtual labs and the theoretical classes, how they will be delivered, those are taking place. Now, in addition to the IPR as an open elective at the BTech level, for the PhD students also, as part of their research methodology program, research methodology course, say we have put IPR also as a 1 credit course. So each and every PhD student will have to go through these IPR issues, because we understand that every student, and for specifically those the PhD students who will be involved in the research activities, each of them must be knowing say what is an that is intellectual property, how this has to be say applied, this has to be maintained, received, and entrepreneurship development will be more useful not only for the pass out BTech students, because say in the current scenario when the standard job opportunities are basically diminishing, so the students say we are expecting that more and more contributions from the NIT Silchar will be there towards the knowledge economy, so that our faculties can contribute in that place. And so finally, I wish the program a grand success and more contributions from the Department of Management Studies and from our distinguished speakers also, because maybe in the near future, you might be say we might be requesting you to address our undergraduate students or our PhD students in some part of their coursework, so that some expert advice they can gain from your parts also. With this, I again wish the program a grand success. Thank you, and I declare the workshop Intellectual Property Rights and Entrepreneurship Development open. Thank you again.
Thank you very much, sir. Now, I would like to share with you a brief, you can say, the overview of the entire workshop, that how and in what manner it will be proceeded in the next 5 days. So as I have discussed earlier, we have eminent speakers, Shri Avinash Kumarji from DRDO, former Associate Director, Mr. Sandeep Agarwal, IPR attorney. Basically, he will be talking about the patent filing procedure and prior art search patentability criteria with case studies. Then we have Professor Rajendra Kumar, Coordinator IPR Cell, Dean of Student Welfare, NIT Kurukshetra. Then we have Dr. Sunil Kumar Yadav, Coordinator Industry Institute Interface Cell, RDIS. Then we have a very renowned former advisor and chief scientist, IP Innovation and Protection Unit from CSIR, Dr. Chetan Kumar. He will be talking about the introduction to international IP protection. Then we have Dr. B.K. Sahu, a renowned, you can say, expert in the domain of entrepreneurship and IPR. Basically, he is a regional manager in NRDC, IDFC, and WIPO Technology Innovation Support Center. And he will be talking on the topic IPR and technology transfer. Then we have Professor Rajat Kumar Beshe, retired professor and head IIT Delhi. Then we have Dr. Satya Ranjan Acharya, one of the eminent speaker in the field of entrepreneurship, basically from the Department of Entrepreneurship Education, EDII Ahmedabad. Then we have Mr. Manoj Das, former director, Indian Institute of Entrepreneurship, IIE Guwahati. And currently he is the managing director of Northeastern Regional Agriculture Marketing Corporation Limited, Guwahati. Then we have Professor Fazal Talukdar, the President, Institute Innovation Cell, NIT Silchar. Basically, sir will talk about IPR and institution-industry interaction. Then we have Professor Gurudas Das, a professor and former head of Department of Humanities and Social Sciences, NIT Silchar. He is an economist and he will be talking about the economic implications of IPR in the 21st century. Then we have our head of department, Dr. Shim Kumar Das, project investigator, IEDC, NIT Silchar, is talking about the economic implications of IPR. And in the next part, I'll be talking about the copyright law and its infringement in academics. So now I would like to thank all the dignitaries for joining and for making their presence at this gracious occasion of the inaugural ceremony of IPRED 2020. Thank you very much, Director Sir. Thanks a lot to all the dignitaries. And now we'll be resuming our first session that will be delivered by Shri Avinash Kumarji. So Shri Avinash Kumarji superannuated from the position of Associate Director, Scientist G, Directorate of ER and IPR, Defense Research and Development Organization, on 31st December 2019. He was responsible for handling entire range of IPR related issues, including providing legal protections on innovations made by DRDO scientists, as well as crafting IPR related provisions in collaborative R&D agreements in his official position at DRDO, New Delhi. He is MSc in Physics from BHU Varanasi and MTech in Applied Optics from IIT Delhi. He has a vast experience of about 22 years in the area of IPR, and he has been a part of evolution of IPR culture, not only in DRDO, but also in India. His consistent efforts and various innovations have contributed in DRDO winning the prestigious National Intellectual Property Award 2015 in the category Top R&D Organization for Patents, and Thomson Reuters India Innovation Award twice, in the year 2011 and in 2014. He is a frequent speaker at different IPR seminar workshops organized by various universities and R&D organizations. He is a well-traveled person across various countries and having exposure to patent laws, contractual issue in R&D, crafting patent specifications, and the like. Sir, we are blessed to have you as an expert speaker for IPRED 2020. Over to you, Avinash, sir. Sir, you can share your presentation. Avinash, sir, are you there? Avinash, sir, you may proceed. Yes, sir. Sir, you are audible. Kindly share your presentation.
Now I'm sharing. Is it visible? Is it visible? Is it visible?
No, sir. No, sir.
Oh, what is the problem? Because it is visible on my screen. I have already shared it. So what to do? Can you share from your end?
Yeah, definitely, sir. I'm doing that.
Okay. I'm audible?
Yes, sir, you're audible. Just give me a second, sir. I'm sharing your presentation.
Okay.
Share करना पड़ेगा. Avinash, sir, is the presentation visible to you?
Yes. So So can I
Okay,
continue?
sir. Yes, yes,
Can
yes,
I continue?
definitely, sir. Definitely, sir. You may continue, please.
Thank you, NIT Silchar and Professor Saurav Verma for providing me an opportunity. And let me tell you, I'm very happy that in this workshop, the part of IP commercialization and licensing has been made the first presentation. Obviously, you are very clear that you want to realize value from the IP. Now, IP commercialization and licensing, and I'm also happy because it's the first lecture, so I can go on speaking without having any fear that I am repeating the thing. Okay, so next slide, Professor Verma, Dr. Verma, or I can myself do that from here. Okay, so intellectual property rights. Let me tell you, it's my habit to clarify the terms which will be coming during my presentation. In any case, this being the first presentation, it's a good idea if I clarify all the terms which will be repeated a number of times during the course of the workshop. So basically, intellectual property rights refers to creation of human mind. Okay, so patent, design, copyright, trademark. So what happens if you have created, suppose I have invented a laser pointer, and if I file a patent application, then I get exclusive right for 20 years, exclusive right 20 years to market it. Nobody else can market it without seeking permission from myself. So that exclusivity, that monopoly rights make the IP created by myself a tradable item. Okay, so basically in essential, legal system of intellectual property rights convert creative outputs into tradable property. That is the first thing. Okay, and then the IP licensing. What is the meaning of licensing? The thing is, you cannot license something if you don't own it. I can't put my house for rent unless until I own the title of the house. And then similarly, the technology transfer assumes ownership of technology. If I talk about technology transfer, if I am able to do technology transfer, then I must own the technology. So these are the some of the essential points. Now, next slide. Dr. Verma, next slide. Yes, IP commercialization. Now, what is the IP commercialization? It's a much, much broader concept. The IP means includes every kind of IP, patent, copyright, design, trademark, and then commercialization. So basically, in a sense, what we are talking when we talk about IP commercialization, it essentially means bringing IP to market for realizing commercial value, making money out of idea. So basically, when we talk about IP commercialization, we talk about how we realize the value IP which I have created. Obviously, IP commercialization is a broader term. It includes IP licensing. It includes technology transfer also. Now, next slide. Licensing. So what is the meaning of licensing? Licensing means permission for use. Basically, it's opening the barrier. Covenant not to sue. It's an agreement. If there is a licensor, if someone who is giving his technology to a licensee for use, then there has to be an agreement, written agreement. That is known as licensing agreement. And once this agreement is signed, then the licensor promises licensee that if we make use for market use, etc., then as per the terms and conditions of the licensing agreement, is not going to sue. For example, if I, under the rent agreement, I give my house to a tenant, then I'm only ensuring that if tenant is entering my house, I'm not going to charge him with trespassing. I'm not going to report to the police. That's all. The licensing is just opening up the barrier. Merely permits licensee to do something with the permission of the licensor. That's all. It has a certain negative connotation. The connotation is that opening the barrier. Next slide, Professor Verma. Dr. Verma. Technology transfer. So what is technology transfer? It's a broader term than licensing. Sometimes people confuse what is licensing, what is technology transfer. basically, when we talk about technology transfer, it includes everything. What is the definition? Second point, that flow of technical knowledge, data, design, inventions, prototype, software, and our trade secrets from one organization to another organization. Essentially, enable a licensee to upskill on a technology. The point is, when we talk about the licensing of a patent actually means, you see, once a patent is filed, after 18 months anyway, it is published. Then after grant, it is published. So it is in the public domain after the grant and even before that. Now, by virtue of the fact that the patent gives monopoly right for 20 years, by 20 years, nobody can use my patent for commercial purposes without my permission. But if I give a license to a licensee, I merely permit him that he can use my patent, that too under terms and conditions of the agreement signed between the licensor and licensee. But when there is a technology transfer from one party to another, say from licensor to licensee, it involves a lot of other things. It involves hand-holding also. It may involve deputation of scientists from the licensor to the licensee. It involves transfer of know-how, data, so that licensee comes to the position of the licensor also. Means the licensee should be able to reproduce the licensed item. Enable licensee to upskill on a technology. So obviously, technology transfer is a much broader term than licensing. I will further explain these terms in the subsequent slide. Next slide, Dr. Verma. Let me tell you, DRDO has very intelligently used these two things, licensing and technology transfer. Now, let me tell you, DRDO has two separate windows. One is DRDO policy for use of patents by Indian industry. I will urge everyone, particularly students, to visit the DRDO site and look for themselves the policy documents pertaining to licensing of patents and the documents pertaining to technology transfer. Now, when I was there in the office, I retired from the office in December 2019, and this policy was concluded. Before that, I was involved in that policy. So basically, what is the objective? Once you read carefully, then you will understand the difference between the licensing and the technology transfer agreement. It says, what is the objective? To provide boost to Indian industries in general and to defense industries in particular through free access to Indian patents held by DRDO. The operating words are free access. So what we are saying, we have published the list of 460 patents on a website, and we say anybody can use these patents on as it is basis. If you want something more than that, whatever is disclosed in the patent documents, you want know-how, you want our help, then sorry, this window is not open to you. This window, you will have to knock at the another window. The point is, but let me tell you, it is very useful. Why we made this policy? Because sometimes what happens, technologies we have, DRDO, you see, it deals with the simpler technology and complex technology also. For example, we have a lab, Defense Food Research Laboratory. Now, in DFRL, there are some of the technologies like food packaging, etc., NBC suit or fire retardant suits. Some of the technologies, there could be one-to-one correspondence with the patent and the product. I will give you examples. Take the example of a mobile. Now, mobile involves a number of technologies. Technologies related to the communication protocol, technology related to the screen, the sharpness, etc. Similarly, there could be a number of other technologies in the mobile. Now, each of these technologies, whether the display or the communication protocol, could be protected by a number of another products. So, one single product may involve a number of technologies, and in addition to that, those n number of technologies may involve a number of patents. Things become quite complex, but there could be some simpler products where this mapping from a patent on a product could be possible. So when the mapping is possible, when you can relate one patent to one item, then this window becomes important. So what we basically the idea was to remove the barrier. We were given an opportunity to potential licenses. Look, we have created patents. We have this 460 patents, Indian patents. We are opening it for you. You just have to fill a form and then payment of 1,000 rupees processing fee, and you have to sign a licensing agreement, and that's it. If you are able to duplicate the product to the patent documents, you are welcome. Okay, so this window is for licensing, merely permission. We will not show you. We give you permission to use it if you can duplicate the item by reading the patent documents. Now, the second window. Next slide, Dr. Saurav. I'm so sorry. I'm troubling you. DRDO policy and procedure for TOT. Now, this is a much comprehensive policy, 110 pages documents. I will urge everybody to read these documents on a website. Now, read carefully. To disseminate DRDO developed technologies to a framework that ensures seamless transfer. Here we are talking about seamless transfer of technology to industry to boost the growth and capabilities of defense manufacturing sector for achieving complete self-reliance. We are talking about self-reliance. We are talking about seamless transfer of technology to industry. We are not talking about a single patent. We are talking about the complete technology pertaining to a licensed item. If it's a complex technology, if it is small n number of patents, then we are willing to transfer all the patents, copyright designs embodied in that complex product under the technology transfer agreement. And here the things are, the agreement will be a bit more complex because what would be the price of that? There will be technology transfer fee. What will be the royalty rate? All those things will be decided some price negotiation committee. First, we will put a price internally, and then will be a price negotiation committee. So what I'm trying to highlight, that technology transfer is a much more complex thing than a licensing agreement. We must understand each and every term when we are dealing with the IPR. Next slide, Professor Verma. Yes. Now, this slide, let me tell you, this bundling of IP is also there. Things become a bit complex. Look at this laser pointer. Now, laser pointer, it involves, suppose, functional features. Suppose this laser pointer, I have already taken a patent for this laser pointer because the time of it can work continuously for 1,000 hours. The total shelf life of laser pointer is 1,000 hours. I have done something in the functional features so that a patent has been granted. I was able to prove novelty, non-obvious, etc., etc. I haven't granted a patent. So the single item laser pointer, the functional features I have protected through a patent. Now, external appearance. This could be protected through a design, external appearance. Sometimes we pay additional price for the look of a watch or a TV or motorcycle, whatever. Those external features are protected for the design, the pen, the laser pointer. Now, I must have a drawing. You see, if some manufacturers want to manufacture n number of pieces in his workshop, then he will require drawings. He will require drawings of the different sub-assemblies, tolerances, etc., etc., engineering drawings. We have those drawings and we own the copyright. Now, suppose the company, say, hypothetically, the company name is A, and I have already a market created with the company name A because of trademark, say Parker. People can associate the certain quality, certain quality of the laser pointer with the name Parker. Of course, Parker is a well-known brand for pen. I am talking about the laser pointer, but this is a hypothetical situation. So the name, if I am lending the name of my company to a licensee, then there could be a separate agreement. And similarly, there could be a chip inside this, and I might have protected through a layout, design, topography, and research. What I'm trying to highlight, I'm just giving a very simple example. A laser pointer. The different features of this laser pointer could be protected by different mechanisms of IPR. So suppose I want to license a patent pertaining to laser pointer. Suppose I have taken a patent for the functional features. The patent is published because it has been granted. Now, if I give a license for the patent pertaining to the laser pointer, now what will happen? the licensee may duplicate the functional features of the laser pointer, but at the same time, since I have not given any other license, he cannot reproduce that laser pointer in exactly the similar design for which I am getting it manufactured. He cannot copy my external appearance because I have not licensed the design rights. Similarly, he cannot demand drawings. He cannot copy my drawings. He cannot sell it, even if he to make it with the brand name of the company Parker. Similarly, so what I'm trying to highlight, if I give license for the patent for the laser pointer, maybe he will be in a problem to duplicate it in the similar shape or similar functionality. But if he wants to duplicate in his manufacturing facility, the licensee, then he will have to negotiate with the licensor technology transfer agreement. And then the licensed item will be defined as the laser pointer with all the patent design copyrights embodied in itself. That will enable a potential licensee to duplicate this laser pointer in n number of. How it will be done, I will come to that. I was just trying to highlight that a single product would be protected by a variety of IP rights, and for each of these IP rights, I can charge different money, licensing of this. Okay, next slide. Next slide. Yes. Now, identifying and owning IPR. On the right side, what I am trying to highlight that IP, let us forget about this thing because there are many speakers who will be going in deep detail about this intellectual property rights. What I'm trying to highlight, suppose NIT Silchar is there, it has its faculty, it has its students, has research scholars, and if something is generated inside the lab, depending upon their IP policy, maybe the ownership of whether it is a patent, design, copyright, trademark, etc., that will be owned by the NIT Silchar. But let me tell you, for a bigger organization, say DRD, even for NIT, things are not quite that simple. In a real world, any scientific organization, any university, any NIT, any organization like DRDO, CSIR, or any technology organization, they interact a lot with the outside world. Let me tell you, on the left side, in the left side, there could be employer-employee agreement, there could be a student, there could be collaboration development, maybe NIT Silchar has taken a grant from DRDO, who will own the IP? It will depend upon the terms and agreement of the grant agreement. Sometimes NIT Silchar get a contract research from IBM to develop some material which can be stand to high temperature. I'm just giving an example. Maybe NIT Silchar is a hire consultant to create a website for itself. Maybe it will be participating some exhibitions. It is conducting workshops, seminar. What I'm trying to highlight that, let me tell you, in the real world, even the ownership of IP becomes a complex issue. If all the IP is generated in-house, maybe things are simpler. Maybe the ownership is decided, NIT Silchar is owning. But if it has hired a consultant to develop the website, who owns the website? Who owns the source code for the website? Suppose NIT Silchar want to modify the website, design of the website, appearance of the website, then maybe consultation permission is required, depending on the terms and agreement of the terms of the agreement under which the consultant was hired. What I'm trying to highlight, in the real world, things become quite complex, and you have to have an IPR group which not only takes care of filing patent, design, and all those applications where the ownership is clear. It has also to take care of all the agreement through which the organization is interacting with the third parties. Because the moment you start interacting with third parties to generate something, the ownership becomes a question mark. And then, unless until you have a clear terms in the agreement, the ownership is not decided. For example, let me give you an example. If, as per the DRDO policy, if granting a product agreement with, say, NIT Silchar under granting aid, then the DRDO policy is that if any IP is generated, then this should be joint. NIT Silchar and DRDO will be jointly owning. But the second point is that DRDO shall be filing IPR application on its own. Of course, it will be bearing all the expenditure also. NIT Silchar need not bother about the expenditure. But DRDO retains the right to use it for use defense purposes, government purposes, and of course, NIT Silchar will also have right to use it for other than government purposes. The point, of course, under a license agreement. The point what I'm trying to highlight that ownership is not that simple if you interact with the third party. So if you are talking about the licensing of IP generated during in a particular organization, you should be very clear whether you own it, because if you don't own it, then you can't license it. Okay, next slide. Next. Now technology. You see, I am trying to demystify the different terms. When we talk about technology, basically technology is all about practical application of information. But the creation or modification of useful products are essentially, when we are talking about technology, we are talking about the inventions, we are talking about the know-how, we are talking about something which can relate to scientists. We are talking about say some organization like DRDO, CSIR, which are working in the area of technology. So when we talk about the technology, and again, as I have already clarified, a product may involve number of technologies and a technology may involve number of patents. Things are not that simple. Okay, next slide. So basically, I have defined what is licensing. I have defined what is technology transfer. I have defined what is commercialization. Different terms have different meaning, some subtle differences, and we should be very careful. Now, why licensing? The question is why licensing? Problem is the new technologies are becoming complex, involving huge investment, financial as well as manpower. Look at the mobile. Now, mobiles are available for 8,000, 10,000. But look at the complexity of the technologies. Maybe the earphone which you are getting with some Chinese telephone, they are giving you Sony earphones from the Japanese company. Maybe the display involves some technology from Korea, Samsung. Maybe the communication model is from Motorola. Yes, Motorola did some pioneering work in the area of mobile technology. And so this cross licensing takes place. You see, you have to pay licensing fee for different technologies to n number of players depending upon the ownership. So what I'm trying to highlight, the products are becoming very complex. It is not possible for a single organization to create a technologically sophisticated product on its own. It will have to take help from the other parties. That's why, because otherwise it will be a huge investment. And there is another issue. Different positioning at technology chain. For example, university, basic sciences, it is their mandate. Industry, production, R&D, development, prototype level. For example, DRDO, we work at the prototype level. We develop a technology in-house, we develop a prototype, we test it under various conditions, and when we satisfy, the engineering ranks are, the production ranks are clear, then if we want to make thousands of pieces, maybe we'll approach potential licensing, maybe Bell for some complex products, maybe DRDO will approach Bell, because we don't have that wherewithal to produce a number of items. So positioning, the mandate of particular organization, university, they are happy if they take a contract license, develop something to a certain level, and then it gives to production agency. For example, IPM give a project to say a university to develop some material which can stand high temperature, and once it is developed, they will take it back and then they will use it themselves, or maybe they will license it to say Boeing company to make use of this in their airframe. So things are becoming very complex, and that is why this licensing is required. For example, say a R&D lab working in the area of life sciences develop some compound which shows some activities against some disease. Now, their wherewithal is just to identify the activity. Once that activity is identified, they will license to an organization which have wherewithal for a clinical trials, phase 1, phase 2, phase 3. Let me tell you, these are very complex issues. Contract has to be signed by the individual volunteer. So they will give it to the they will give it to some other organization which will take care of this thing. CROs are there, clinical research organization. They will take care of the clinical research, phase 1, phase 2, phase 3. And once that is clarified, but is clear, even then that second stage, they may not have wherewithal to produce for thousands of to supply the entire world. So they will approach another player working at the higher level to manufacture it. Let me tell you what is happening. You must be, if you are reading newspapers carefully, what is happening in the case of vaccine being developed. There are 100 players developing this vaccine. But let me tell you, the vaccine is to be supplied to the entire world. Then any, say, AstraZeneca, hypothetically, they will have to enter into the license agreement with the producers of vaccine in the different regions of the part of the world, so that those particular licensees will produce at their manufacturing plants under their guidance, under their quality control, so that produce, and then, of course, when it is sold, they will charge certain royalty. For example, Serum Institute in Pune. So this is the norm. You see, one organization cannot do everything. Produce, invent something in the lab, and then manufacture it in n number of pieces. The research is becoming multidisciplinary. Core competence in different sectors. Product diversification. Suppose some activity, one organization has developed some compound which is very effective against insecticide. Now, if they want to diversify into the weedicide, the same with some tinkering of the compound, then they will approach some other organization which is doing some good work in the weedicide area. So these things, market diversification, as I have told you, if AstraZeneca is interested in selling the vaccine to different parts of the world, then they will have to approach different manufacturers of the vaccine, so that in a shorter time period it could be supplied. So the point is, you see, the complexity of the technology, complexity of the market, this licensing is the norm. This is the norm. Next slide. Dr. Saurabh, next slide. Yes. And one thing I want to highlight, this is very important. Please understand very clearly that there are three distinct domains. Creation of technologies. Who created technologies? Scientists. Now, legal protection of the technology. Who provide the protection? IPR professionals like us. But when it comes to commercialization of technology, then technology transfer professionals. What I am trying to highlight, please understand, a scientist's job is to create technology. If you involve scientists for drafting a patent application or interacting with the attorneys and visiting the patent office, you are not doing justice with the scientists, because it's an altogether different game. When I was in DRDO, when I used to draft the patent specification, of course, we had attorneys are also on panel, and when the final patent document will come, the scientist will himself be surprised. Oh, I have invented this thing. Because when we draft a patent specification, we have to foresee the different embodiments, future embodiments of the invention. We have to give proper protection, because scientists, suppose he is inventing he is working on some gear mechanism of a complex BMP or MBT. I'm just giving a hypothetical example. Now, he all the time, since last 10-15 years, he has been working in the area of MBT tank. He is all the time, from day and night, he's only thinking about them. Suppose he develops something for the tank, say a gear mechanism or whatever it is. Now, he will only take a protection for gear mechanism or some material which can be used for the tank. But when he used to visit our place in DRDO headquarters, we will start asking questions: can it be used with slight tinkering in a passenger vehicles also? Then he'll be surprised why I'm talking about the passenger's vehicle, because that is not our mandate. But as an IPR professional, my job is to ensure that in the future, with some tinkering, the potential infringer should not get out of my reach. The point is, I have to foresee the future embodiment and capture it today only. Now, the scientists will not be able to appreciate all these things. The language of the claims will be entirely different. It's a total, my friend from the IP attorney firm will appreciate this, that it's a very difficult task. And similarly, commercialization technology. Again, when it comes to commercialization, you need certain other type of expertise, market people who know the market, who can read the pulse of the market, and who can take a dispassionate decision whether the invention is fit for the market or not. Let me tell you, even a breakthrough invention may not fetch you money if it's sent to the market, because maybe the market is not ready, maybe the item has become redundant. So sentiment has no place when it comes to commercialization of the invented item. You see, only 7 to 8% patents are really commercialized world over. What happens to other patents? I will not go in detail because the other lectures are also there. So you can realize the value of your invention when there is a complete synergy in all the three activities: the scientist, the IPR professional, and the marketing people. The moment it is invented, you file a patent so that it is protected. And once it is protected, or even from the day of filing a patent application, people start talking your commercialization, TTO people start talking with the potential licensee. And once there is synergy, then only you can realize the true value of your invention. Otherwise, the time will be lost. And let me tell you, this is very, very important. And when this synergy happens, then only you are able to realize the money. Next slide. Next slide. Yeah, non-disclosure, I will just mention just a second, because once you are ready for technology transfer, once you are ready for the license agreement, then it is a good idea to sign a non-disclosure agreement. That is a standard practice people will be doing, because if you start talking with a potential licensee, you will be disclosing some of the drawings, the item, etc., etc. So you sign a license agreement, NDA, and basically the terms are that whatever is being disclosed during the negotiation, it will be used only for the assessment at the licensee end, whether it is suits his requirements or not. And suppose he is not interested in signing the license agreement, then all the drawings, etc., will be returned. And next point is that he will not be taking IP protection based on information disclosed during the negotiation. So that is a NDA. Drafts are available on website, and this is very, very important. Because you will be talking to 10 potential licensee. Out of 10, maybe only 3 will come forward for licensing agreement. What happens with the rest of 7? Rest of the 7 are required to return the information or destroy the information, whatever is them. They are not supposed to enter in your area, exact area. Okay, next slide. Next slide. Yes. So the mechanism of technology transfer, basically you can assign, sometimes individual inventor, they assign all right, they transfer the ownership, they are not interested in pursuing any further. For example, as I was giving example about the pharmaceutical product, some compound has been invented by a lab, a small lab, and it has got some huge potential. So, but they don't want to involve in the negotiation with the CRO, or again then at the higher end with the pharmaceutical company. They lack that wherewithal. Let me tell you, these negotiations are not very easy. You have to have requisite expertise, etc. You have to have experts, and sometimes it becomes very difficult. So what they will do, they will assign the right. They will simply transfer. I am no longer interested. Give me huge amount. Whatever you do with my invention, I really don't bother. And licensing, I have always already talked. Granting permission, cross licensing, exchanging IP right, setting up joint venture. This is also obvious. Sometimes patent pooling arrangement. This is done, say consortium. They come forward. Suppose then some kind of a protocol is being developed, communication protocols, say mobile, etc. So the Ericsson and other companies, they will have some consortium kind of thing. They will pool their patents so that some standards is developed, so that standard communication protocols are developed, so that people are able to use mobiles from all the companies with a common protocol of communication. There are no problem because of the different types of mobiles. and here the concept of standard essential patents are coming. I will not go in detail. The point is there could be different mechanism of technology transfer also. You can create a consortium, etc., etc. Next slide. But for our purposes, for the purposes of this workshop, my topic is IP commercialization and licensing. So I should not lose sight of the topic which I have been assigned by NIT Silchar. I should not deviate from my topic. Now, so basically coming back to the license agreement. So far, I have been trying to clarify certain terms, demystify certain terms, because these terms will be being used by other distinguished experts again and again. So it's a good idea if the people have some clarity about the different terminologies. Now, signifying license agreement. So what is the license agreement? Unless basically it signifies business relationship, rights granted for use of intellectual property by the licensing. The point is, suppose going back to the earlier laser pointer example of laser pointer, if a licensor, suppose a organization, say Parker, has developed a laser pointer and owns the IP, all the IP about the laser pointer, and it is interested in getting it manufactured by n number of companies across the world, then it will be entering into the license agreement with the n companies, under which, and the terms and conditions will be decided under which those licensees will be producing that laser pointer for the consumption throughout the world. And for that, a written agreement will be signed. In fact, in our Patent Act, Design Acts, Copyright Acts, there are separate provisions, licensing provisions. I will not go into detail. The point is, as per the different clauses of those acts, the agreement should be in writing. Only then you can enforce it. Now, again, it presumes ownership of intellectual property right. I come back to again and again ownership, because that is very, very important. Now, when we talk about the IP commercialization, if IP is about the copyright, then there could be separate copyright license agreement, trademark license agreement, software license agreement, technology transfer agreement. Let me tell you, this copyright, this trademark, this software, these are again highly specific fields. There could be some expert, licensee experts, who would be dealing only with the software licensing. There could be some experts who would be dealing only the trademark license agreement. There could be experts who would be dealing only copyright license agreement, because each of these issues are in themselves very, very complex. Let me tell you, I have seen license agreement about the software, quite a piece of literature. It could be run into 50 pages. Sometimes even a definition will run into one full page. Sometimes the terms will be repeated again and again. Same thing will be said with emphasis, twice, thrice, to make things very clear. And sometimes, instead of making things clear, it becomes quite complex for the ordinary scientist to understand. For example, in the case of the copyright license agreement, the copyright is a very complex topic, let me tell you. Notwithstanding the fact that you don't really need to get it registered in order to enjoy the right, it could be very complex. Think about some song, musical rights. Now, the music could be released on a CD. Okay, music could be released for TV. Music could be released on the internet. You see a different platform. For all this platform, what the licensor can charge different money. There could be separate agreement. You see, once a movie is released first in the theater, and then it is released on the channel, say Sony, then it is released on the internet, and finally it is released in the form of CD, and then it is available on the Amazon also. The point is, there should be different layers of agreements, because suppose author, somebody has written a novel. Now, if the author, the owner of the IP, wants to get it published through a publisher, then he will be entering into an agreement with the publisher. Let's say license agreement. He is licensing his copyright right over the to the publisher. Now, you see, there could be different kind of things which ought to be tackled in a copyright license agreement. For example, suppose tomorrow the book is to be translated into different language. Now, again, if it is translated by some author, another right will be created. The point is, you see, if somebody wants to write a license agreement for a copyrighted material, it can involve n number of complexities, and you have to foresee all those situations beforehand and take care in a copyright license agreement. So if you are IP commercialization, my topic, if you want to commercialize your copyright, then you may have to approach a licensing professional who is expert in this area, because the issue could be quite different. Similarly, trademark license agreement. If you are, suppose in laser pointer, if the Parker wants to, hypothetical company wants to get it manufactured by potential licensee, and it also wants that licensee can use the name Parker, sell it with the name of Parker, then a trademark license agreement. He is lending his name, he is lending his goodwill. Now, some additional things have to come in the license agreement. What are those additional agreements? The Parker company will have to ensure that there is a definite quality control mechanism. Because if there is no quality control mechanism, if the laser pointers doesn't work properly, then the goodwill of the company Parker will suffer. Okay, so once you lend your name to a potential licensee, then you should be very careful. You will have to have a clause that the licensor can periodically visit the licensee's premises to ensure the requisite quality control mechanism of observed. Some quality control manuals has to be followed, provided by licensor, periodic checking, etc. So some additional feature has to come. And then territory, etc. Those things will be common. Similarly, suppose software license agreement. I think software, you see, it's a very complex thing. Software license agreement. If I am taking licensing in a software to be used in my premises, then imagine what are the things which I must take care of. First of all, if license is used on a platform, my own platform, which I have created, or maybe third-party platform, I must ensure the license doesn't correct the platform itself. It should function it should function clear. It should not have any bug. It should not have any bug. And then if it fails at any point, then the licensor should provide some backup feature. Then if there are some upgrades, he has to provide upgrades. The software license agreement. And so the point is, each area, whether it's the software, whether it's a trademark, whether it's a copyright, each area has its own complexities. And the person involved in drafting the license agreement should be aware of all those complexities of the area. And then he has to ensure that there is no disagreement between the licensor and licensee at any future point of time. There should be absolutely clarity between the licensor and licensee. What is the role of the licensor? What is the role of the licensee? All those things should be clear. Otherwise, it will give rise to dispute. And then finally, technology transfer agreement. It's let me tell you, it's basically it's about technology, as I have explained earlier. It is easier to deal, and maybe it is more relevant for this workshop purposes. Next slide. Next slide. Okay. So now coming to the license agreement. Now talking about the IP commercialization, talking about the IP, talking about the different type of IP, different type of complexities involved in, say, copyright licensing and software licensing, trademark licensing. Let us come to some common features of a license agreement. No doubt, there will be some common features, and in addition to some complex issue pertaining to individual type of technology, whether it is, individual type of it's a software, copyright, trademark. So basically, in a license agreement, there are four essential things. These are common features. I'm not saying, let me tell you, in the presentation, I'm just trying to capture some of the essential points. And you may require the help of expert if you are really trying to draft a license agreement. Okay, so that disclaimer I want to make it very clear. I'm just trying to highlight certain features. That's all. So subject matter of the license, that is number one. The scope of rights, commercial consideration, and some general clauses, boilerplate clauses, which are which ought to be there. So these are the four basic things which form the part of a license agreement. These four things have to be there. If there are some additional things, no issue. Next slide. Next slide, Dr. Saurav. I am so sorry. I'm unable to change it from my end. Now, the license agreement, the subject matter involved, who are the parties, preamble, definition of the terms, then scope of rights, what are the territory under which this license agreement will be enforced, what about the improvement, suppose it is about the laser pointer, tomorrow some improvement takes place at the licensor end, development, notification, modification, who will own the IP pertaining to improvement, development, and modification, whether done at the licensor end, at the licensee end. What about the grant? It could be non-exclusive, exclusive. I will come to that. What is the term of the license, sub-license, infringement, indemnity, warranty, product liability? Product liability becomes extremely important in the case of drug. Commercial consideration, if licensor is giving permission to licensee to manufacture, say, the laser pointer, what are the commercial conditions? What will the royalty, technology transfer fee, sometimes currency, if it is international agreement, mode of payment, milestone payment, one-time payment, royalty, recurring payment, account books. Can the licensor check the account book to ensure that he is getting the requisite royalty, or he is not being fooled by the licensee? It becomes a huge issue, let me tell you, in the practical world. Licensee will say he'll make only 100 pieces, and he licensee may be making 1,000 pieces. So you have to be very careful. General class termination, dispute resolution. These are the certain things which ought to be there in a license agreement. So in the next few slides, I will be highlighting why these issues are important. Next slide. Next slide. So basically, there are parties. You have to define the parties. Some of the preamble, we say, since Parker has developed an example of that laser pointer and coming back to again, so as to make things very eloquent for the participant. Let's say the Parker company has invented a laser pointer, and a company A is interested in getting license from the Parker to make it thousands of pieces, say for the USA or some any other market. So some context will be said that whereas clauses, we call it whereas clauses, whereas Parker has developed a laser pointer, whether he owns the IP, whereas company A is interested in taking license to supply to the world market, and thereby this party including this license agreement. So the preamble is basically putting the things into context. It becomes very, very important, and identifies parties, party A, the address, party B, the address. Okay, so there has to be clarity, because if there is any dispute, this agreement will be read very carefully by the court of law. Next slide. So these are the essential points, and then define. This is very, very important. Let me tell you, I have a collaborative agreement. I have been involved in many negotiations, and I have seen many agreements at different levels. Definition is very, very essential. During the negotiations, you should be very careful the definition part, because in any dispute, whatever you can be your own lexicographer, forget about the dictionary. The way you are defining the terms in the beginning of the agreement shall be taken into account by the court of law in any dispute. So you have to define what is eligibility rights, what is confidentiality, proprietary information, license product process, very important. So what is the license product? the entire laser pointer along with the IPs embodied therein. You have to define. If licensed product is the patent related to functional features of the laser pointer, then you will say the patent number this. Maybe an annexure will be added that these are the IPs pertaining to laser pointer which is under the license agreement, which are being licensed. So the definition is very important. What is the licensed product? It is only the patent or the complete product laser pointer. License right. What are the license right? I will come to that. Know-how, unit price, territory, all those things need to be defined. All the terms which will be recurring during the agreement again and again, these terms should be defined at the beginning of the thing, so that wherever it is happening, if know-how is being repeated at n number of places in the entire agreement, the meaning remains the same as per the definition. There is no contextual issue involved. You cannot say know-how should be taken in this part of agreement in this manner, and on page number 9 in this manner. No, we have already defined it, so that it brings clarity of thought, clarity of action. Next slide. Next slide. So again, definition. What we write? For the purposes of this agreement. Yes, definition could be different. The dictionary definition could be different. I'm not bothered about that. But for this part of the agreement, sometimes the license agreement, say collaborative R&D agreement, the IP, there will be a separate template. And I will say, for suppose I am drafting the IP template for a collaborative R&D agreement, then I will say for this part of the agreement, for which part, the template which deals with the IP rights. I will not go into detail because that's altogether a different subject matter. Here, let me talk about the license agreement, IP commercialization. Now, the license, for the purpose of this agreement, the following terms shall have been indicated, meaning license property, schedule containing the list of license. Yes, so you should have a schedule. Suppose the laser pointer, the licensee is interested in taking license so as to produce the complete product. He will be taking license for the design right, for the patent right, for the copyright, for the IC chip right, all those things. And this rights, I have taken a patent, granted patent, filed patent, all those lists has to be a part of schedule. Okay. Then only the agreement is complete. The licensee should be very clear what he wants from the licensor. Licensor should be very clear what he wants from the licensee. Next slide. And let me tell you, even to know what we want for a licensor to decide what he wants from the licensee and from the licensee in what he wants from the licensor over a period of time during the term of the agreement is not an easy thing. You require certain experience, you require certain perception so as to list out all those things. We call it term agreement. Okay. So proprietary information, we will define. You don't define proprietary information as something which is already in the public domain. That's what the definition says. But suppose a licensor, this is a laser pointer, you see, it's not design rights, patent right, etc., different. But know-how is something which is very important in terms of the technology. For example, a chemical reaction. Even the reactor, what kind of reactor will be used for the chemical process so that the maximum yield is generated for a chemical process. Reactor could be very important. And that forms the part of the know-how. This know-how is very important. And suppose this know-how is a part of the deal license agreement, then the document know-how, suppose he marks confidential, then it is the licensee duty to keep it confidential during the term of the agreement. And somehow it is disclosed to third parties, this could be construed as a fundamental breach of the license agreement, and it could give rise to the termination of the agreement also. Next slide. Next slide. So the grant. What is the grant? You must have heard what is exclusive grant, sole exclusive license, sole license, non-exclusive license. Exclusive license means to the exclusivity of the owner of the IP also. Suppose I have taken a patent, I am the owner. If I give exclusive license to a party A, then all rights to party A. Even I cannot make it for myself. It is the exclusion of the owner of the IP also. Sole license means owner as well as the party A, only two parties, the sole license. Non-exclusive means to the exclusion of no party, meaning if Parker is interested in getting his laser pointer manufactured by n number of parties throughout the world, then it should enter in non-exclusive license. As a rule, I have seen government organizations always enter into non-exclusive license because they don't want that. Suppose the problem is exclusive license is, suppose you give license to a party A or even a sole license. What happens if that particular licensee doesn't do anything? For 3 years, he's sleeping on your technology. What will happen? You are not getting the requisite royalty, etc. Of course, you can terminate if he's not working for 3 years. You have a clause to the effect in your agreement, but time is lost. So you would like to give it to a number of licensee so that at least a few you are getting money from at least a few licensee. So government organization mostly give non-exclusive license. Of course, you can give non-exclusive license for a particular territory. One non-exclusive license, say UP, one non-exclusive license for the Bengal. So you are creating exclusivity even within the non-exclusive license. So the point is, it depends upon the technology. Say it's a complex, say drug-related item. There huge expenditure is involved, huge capital investment is required. Then the licensee would like to have exclusive license. At least he doesn't want that some other party should be there and who would act as a competitor. So it depends upon the technology, the type of complexity of the technology. The term may depend upon the type of the technology. If you're a drug, it could be 20 years. But you should be very clear, if you are licensing a patent, it cannot be the life of a license agreement cannot be more than the term of the concerned IP. If you have a patent and you are licensing that patent, you cannot license it for more than 20 years. Okay, so that should be kept in mind. And then ideally, I will always advise that you should have a separate license for a patent and know-how. If you are licensing something to a third party for production of your invented item, it's a good idea that separate license, even in the agreement, you can say license for patent as well as know-how. Suppose by some reason patent is found to be invalid, then you cannot take royalty for the patent. But since you have transferred the know-how, you can still charge know-how. Next slide. Next slide. So the scope of rights, sub-licenses, you don't want that you have given a non-exclusive license to party A and then party A give in turn sub-license to a party B to produce that item. So what will happen? Generally what happens, the royalty is calculated based upon the profit earned by the licensee. Maybe 1/3 of the profit, 1/5 of the profit. Now, if the licensee himself has given a sub-license to a third party, you can imagine what will happen to the royalty earned by you, because he will be sharing the profit with his sub-licensee. Your share of the cake is decreased. By default, if you have not written anything in the agreement, the licensee have no right to license, sub-license, but it's a good idea that you insert a clause that the licensee, the non-exclusive licensee or non-exclusive licensee cannot give further sub-license to a third party. And then infringement. What happens if the item which is put in the market by the licensee, somebody starts copying it, or the product itself comes under infringement suit by a third party? Whatever is the situation, it's a good idea that licensor and licensee, generally that is the standard terminology, they should come together, they should consult each other and then take appropriate action. I will not go in detail, but similarly, whether a third party is infringing the licensed item being produced by the licensee, or the product itself is found to be infringing of IP of some third party, whatever the situation, the parties should come together, consult each other, and then take appropriate action. Next slide, Dr. Saurabh. Indemnity. Okay, let me tell you, there are certain things. See, even a granted patent, mere grant of a patent doesn't guarantee that patent will be found valid in a court proceeding. I have done some research and I found out in case of Europe that more than 50% of the patent, if they come under the opposition proceeding in the EPO, or if they are challenged under an infringement proceeding, because if you have taken a patent and a defendant is infringing your patent right, then you will file a suit in the court of law that, look, this party is copying my patented invention. Now that defendant, that party has all the rights to challenge the validity of your patent. It will say your patent itself is not valid. So what you see, what happens, the ultimate proof is in a court of law, whether your patent is valid or not, because defendant will challenge the very validity. He will do everything. He will make every effort at its command to prove that at least some of the independent claims of your patent are invalid. So basically, what I am trying to tell you, that a licensor should never say that whatever patent is under, if the patent is under license, the licensed patent is legally issued valid. He should not indemnify the licensee. You see, at best, what it can be done, licensor can insert a clause that if the licensed patent is found to be invalid, then all the royalties which has been taken by the licensor shall be returned to the licensee. That's all. What I am trying to highlight, you are never sure that a granted patent is valid. At best, you can warrant, you can say in the agreement that a patent is granted and the patent is valid by virtue of making payment. You are paying the annuity. Okay, but you should never say that it is a valid patent. Okay, so you should be very careful. Generally, it is the duty of licensee to ensure that the patent under license is an enforceable patent. Okay, next slide. Product liability, as I told you, you should be very careful. Sometimes in the case of a drug companies, you see, if a drug is being licensed, a particular drug is on the subject matter of license, licensor will insist the licensee should take a product liability insurance also. If a patient takes a drug, something happens to the patient, liability should not come back to the licensor. Licensee and is a standard practice, they take some product liability insurance so that the licensor is protected. Okay, so basically it is the duty of the licensee to ensure that if he is interested in taking a patent or whatever IP right from the licensor, it's a valid right. It will fulfill his requirements. It is the duty of the licensee, not the duty of the licensor. And the warranty clause is basically one party representing positively to another party a certain position. As a rule, licensor should never warrant that license rights are valid. That's what I wanted to highlight. Licensor, at best, it can say till the date when the agreement is being signed, he is not aware of any infringement proceeding or some invalidity proceeding against the licensed patent being pursued in any court of law in India or anywhere world, depending upon the agreement. Licensor may warrant that license rights are unencumbered or enforced. At best, you can say, no, there is no partitioning of the right. There is no other party. It's not co-owned by some other company, and it is enforced. I'm paying the annuity. That's all. Licensor should never say that the licensed patent is a valid patent. That's what I want to highlight. Next slide. So scope of right, territory. You can license a patent in one territory, as I have already said, depending upon the interest. License will be for a small town, number of licenses for number of territories. Yes, that's how you, for example, take example, biodigestor. Biodigestor, an item developed by DRDO. Essentially, an interesting item. It was developed by DRDO for use in Siachen. See, the waste material, human waste is not degraded because of the lower temperature. It was developed, so some microorganism were developed, and it will degrade the human waste. And now those biodigestor will be will be made for all the railway coaches. So many coaches. So there are 50 licenses. So depending upon the popularity of the demand of the item, there could be a number of licensee, and then you can identify different licensee for different territories. Improvement, development, modification. Yes, if the yield is improved, development, modification, reciprocal licenses for improvement. You cannot say, you cannot force a licensee that if some improvement takes place, because licensee will be also doing some tinkering with the product under license, and if some improvement takes place, he comes up with a bright idea so that the yield is improved. Suppose it's a chemical process, you cannot say that you cannot force licensee that all the IP rights pertaining to improvement should be granted back to the licensor. No, it will run foul with the competition law. What you can do, whether the improvement, development, modification takes place, whether at the licensor end, at the licensee end, they will again, they will cross license, or they will use it together, so that the product remains relevant in the market. You see, technology is a dynamic thing. The product which is relevant in the market may become rapidly redundant in the next 2 years if requisite improvements, modification, developments don't take place. So it is the interest of the licensor, it is the interest of the licensee that they keep on improving the products, they got licensed item, so that the item remain relevant, which is will be beneficial for the licensor as is the licensee. If the item is relevant, licensee will be able to sell it. If he is able to sell it, he will realize a value. Then he will be able to pay royalty to the licensor. It is in the best interest of both the parties. Next slide. Next slide. Royalty is a recurring payment, generally 1/5 to 1/3 of the profit earned by the licensee at a convenient stage. So when the first piece, you see, generally what I have observed in the government system, once the agreement is signed, then some money is transferred. They call it technology transfer fee. Say the laser pointer, if the company A is able to finalize a deal with the potential licensee company B, then it will like to see, at least smell the money at the very first stage. So it will say that, okay, I am transferring the technology, give me this particular, say 1 lakh, 2 lakh, whatever is the money. And once the documents, know-how, etc. is transferred, then there could be another stage for making some payment. And third, when the first piece is out of the factory, with the help of the licensor, know-how, etc., transfer, tolerance transfer, etc., then again there could be certain fee. These are called milestone payments, because the licensor is interested to see some money at different stages, so that his interest remains, his commercial interests are protected. He doesn't want that unless and until some item is produced, the licensed item is produced in the market, which may take, say, 2 to 3 years, he will not get any money. He wants money at the first stage, second stage. So there could be, it depends upon parties. Okay. Royalty per unit of the royalty is something which is recurring. Every piece, suppose 3 rupees, 10 rupees profit is generated to licensee, maybe 2 rupees probably back to the licensor. And yes, I have the last point, maybe in terms of down payment on signing, on transfer of technology, on first sale. The point is, licensor has to ensure, once the license agreement has been signed, that licensee is working on the licensed product. He is not working, then it is not interest of the licensor. That's why this milestone payment, signing and transfer of technology, drawing, etc., and then on first sale. Next slide. Then currency of payment, provision of conversion rate at, suppose you are taking royalty in dollar, what should be the conversion rate, mode of payment, annual, half-yearly, quarterly, royalty, it will be taking quarterly, half-yearly, maintenance of account book, licensor should have right to check the account books of the licensee. These are some standard provisions. Next slide. Next slide. And then termination process should be there, sub-fundamental breach, as I have told you. You see, you can have a clause that if for 3 years the licensee is unable to introduce any single item in the market, it should be deemed as terminated. You should have some control. Licensor should have control over the agreement. If it has no control, licensing is not doing anything, then his interest is suffering. Maybe he has given only 3 non-exclusive license and all the 3 are not working, then his interest is suffering. So he should have some control mechanism in the license agreement. You see, these are the things when I said, when you are signing a license agreement, it requires certain perception, certain experience. And this experience perception comes to the technology transfer people. Of course, he will be consulting as far as the technology is concerned with the scientists, but this is not the domain expertise of the scientist. The scientist's job is to invent something, and then as per the IP protection, IPR professionals should come into the picture. And if the license agreement is being signed, then different kind of expertise is required. Then only you will realize the true value. Otherwise, even you have invented a wonderful product, you have not taken a proper protection, the claims are not brought, then patent is not a patent will not fetch you the right value. And if even a patent is there, the item is there, you have not signed a proper license agreement, then what will happen? You have not strategized your licensing position. You have not strategized how you are going to market. I give a classic example. See, the Dolby. What the Dolby is now taken as a synonymous with the quality of the sound. Dolby was a gentleman who invented noise reduction. You see, he got patent about the noise reduction patent. He got this technology patented, and then what he did very cleverly, when this patents was being used in the item, say radio or somewhere else, the background hissing sound was reduced, the name Dolby was there. He always so license his item with the name Dolby. Now the term of the patent is 20 years. After 20 years, anybody can copy the patent. But my dear participants, what will happen? People can copy the patent, but people cannot sell that technology with the name Dolby. So over a period of 20 years, even if any party is free to copy that patent, parties cannot sell it with the name of Dolby. Now, Dolby has established a name in the market. Now, the people interested in this technology will always go back to the Dolby because they will have what should I say, that name connotes the quality. So even if there are 10 suppliers, people have a tendency to go to the Dolby. That is the strategy. Trademark is unlimited. The term of the trademark could be 100 years, 200, life of the company. Now see, the Dolby, you see, whether you are looking at the PC, there is Dolby Vision, Dolby Atom, Dolby Movie, Dolby Picture. You see, the Dolby is synonymous with the quality of the sound. That is a brilliant marketing strategy. So you can use the different tools, as I told you in the beginning. You can use the different mechanism of IP to broaden the scope of your rights. Even if you have taken a patent for the noise reduction, 20 years it will become redundant, but the name will not become redundant. The name Dolby can go for indefinite period. So that's what I wanted to. Then termination can always occur in case of fundamental breach. If trade secret is developed, is disclosed by the third party, then you can have a fundamental breach has happened. If he's not doing anything for the 3 years, then breach has happened, and the licensor can terminate the license agreement. Next slide. Next slide. Next slide. A dispute resolution Yes, there could be different mechanism. I think we have skipped the slide. Generally, can you go back to the previous slide? I can understand I am exceeding my time limit. Dr. Saurabh, can I go back to the earlier slide? Okay, questions. Okay. No, before that. Basically, in the technology agreement, the parties prefer the arbitration process for dispute resolution. It should become a part of the agreement, because in the when you are handling your dispute under the arbitration, that proceedings are faster, and then proceedings are confidential. If agreement is about a technology you don't want to be discussed in an open forum, you want that particular things, if there is dispute, to remain confidential. So arbitration clauses are supposed to be the preferable choices. There could be mediation also. There are different kind of dispute resolution mechanism. Even for arbitration clauses, there could be different forums, WIPO forum, ICC Chambers of Commerce forum. There is a forum in Singapore. Depending upon your choice, international parties may have different choices. So next slide. I think next slide, Dr. Saurabh. Yes, questions. So I hope I have not exceeded my time, and I have basically my idea of the presentation was to highlight certain essential features. Let me tell you, within 45 minutes and 1 hour, you cannot cover the topic entirely, but at least you can give some highlight you can flag certain issues. So tomorrow, if somebody is going to sign a license agreement, he should at least address these issues in the license agreement. That's all. Thank you. Thank you.
Thank you very much, sir, for such an informative session on IP commercialization and licensing. According to the feedback and according to the reviews which we are receiving continuously from the starting of this session, the participants have enjoyed the session, and they have certain queries regarding the topic, that is IP commercialization and licensing. So first of all, I would like to mention here that most of the, you can say, the IP energies are flowing into the country, but people are basically less aware about how to protect those intellectual property rights that they have created. So some of the certain queries we have, and we will take one by one.
Yes, Dr. Saurabh, I'm audible.
Yes, sir, you are audible, sir. Just wait for a second. I'm just sharing the question answer.
Okay.
Sir, can you see the questions on the screen?
Yes. Mr. Arun Kumar is asking, when you give a license, are you giving the total ownership or a partial ownership? No, we are not giving ownership at all. You see, if I have a home and I am giving it on rent basis to a tenant, I need not share the ownership of the house. No, ownership remains with the licensor unless until it's a exclusive license. Then things become a bit difficult. Okay. I am giving permission. That's all. Permission to use my IP. License means permission. That's all. Now, Dr. Narayan Gotala has asked, what is the role of IPR in the rural entrepreneurship growth and development of India? Let me tell you, the role of IPR, it's a very broad question, but as far as the entrepreneurship is concerned, let me tell you the basic issue is if something developed at the rural level, say some implement which is used in the harvesting mechanism or some compost which is able to raise the yield of a particular harvest, then it is a good idea if some exclusivity is given to the developer, the entrepreneur, for certain period of time, so that he can reap the benefit. So IP will have a role for rural entrepreneurship. Of course, when it comes to the Indian agriculture, maybe it could be applicable for implements, etc. But harvesting method, etc., these are not patentable items. Okay. Mr. Vikas Vinod is asking what is the difference between the legal protection, professional, and technology transfer, professional. You see, there is no difference. Technology transfer, professional. You see, legal protection professional, IP professional. When we say that legal protection professional, IP professional, maybe he's a patent agent. He is well versed with the laws of copyright, design, trademark, etc. When it comes to technology transfer, what I was trying to highlight, you see, even one professional can be an inventor, he can be IP professional, and he can be technology transfer person also. What I was trying to highlight, all this is area require different level of expertise because you should be well versed with the technology transfer agreement. What are the certain points that ought to be covered? What then he should have some marketing experience also. He should have an pulse of the is different. The orientation of the IP professional and the orientation of a technology transfer professional is different. Let me tell you, in DRDO, there was a separate IPR group and separate technology transfer group because the role is different. Okay, technology transfer people all the time they will be talking to the industry, while IP all the time we are talking to the lab. We are more in sync with the science. We are IT professionals are more in sync with the science because they have to understand the science. They have to understand the technology so as to protect it. While the technology professional role is entirely different. Dr. Narayan is asking how to determine the price in case of technology transfer. That is something. There are different mechanisms. They call IP valuation. There are different methods. It will form a separate lecture. There are methods, but let me tell you, my dear friends, very difficult to reach at an exact price. There are professionals. There are several parameters who will give a certain value to a developed technology, okay, depending upon the need for the market. But I will again go back to the classical example. Sometimes it becomes very difficult to predict how a technology will, what should I say, evolve in the due course of time. When DRDO, when we file a patent application on a biodigester, we thought only 40 to 50 pieces of biodigester will be made, which will use in Siachen because which will help in degradation, biodegradation of the human waste. And we never imagined at that time that 50,000 coaches will be using this biodigester. Of course, there is a projection. It's a projection because in railway coaches, you have observed the solid waste is thrown on the railway track. So if this biodigester is used in railway coaches, that solid waste is converted into water. So what I'm trying to tell you, it becomes very difficult to predict how a particular technology will evolve. Even the scientist may not have anticipated when he was inventing this biodigester that will be used in the railway coaches. It's very difficult. Yes, but there are methods. I will not say there are methods. There are professionals. There are mechanisms to put a value on the technology development. So there are 4 questions. I have answered all 4. Any other question, Dr. Saurabh?
No, sir. No, sir.
Or any counter question? No.
Okay. So thank you very much, sir. We are blessed to have you here in the inaugural session of 1 week workshop on intellectual property rights and entrepreneurship development 2020. So now I will like to invite our next speaker for the day, Mr. Sandeep Agarwal. Mr. Sandeep Agarwal is a seasoned intellectual property professional with over 10 years of experience in managing in managing, advising, and consulting on various issues related to IP laws. As in-house patent agent, Sandeep has worked with India's leading pharmaceutical and biotechnology companies and has managed global patent portfolios. He has drafted numerous opinions on freedom to operate patent oppositions, invalidations, and revocations. Has previously worked in a Tier 1 intellectual property law firm, leading patent practice, and has handled patent prosecution of inventors in healthcare, diagnostics, chemicals, and pharmaceuticals. Sandeep has a dual postgraduate degrees in biotechnology and intellectual property law and has been trained at Lewis Business School, Rome, Italy, in the IP management and valuation. He is a registered to practice before the Indian Patent Office since 2009. Mr. Sandeep Agarwal is a member of Asian Patent Attorney Association and basically he is presently serving with a boutique IP consulting firm with thriving practice in South Asia, Adastra IP, serving SMEs, startups, universities, and incubation centers. Without taking much more time between the participants and Mr. Sandeep Agarwal, I request Mr. Agarwal to kindly share his knowledge in the domain of intellectual property rights with the participants. Over to you, Sandeep sir.
Thanks a lot, Dr. Saurabh. I hope I'm audible.
Yes, sir, you are audible, sir.
Okay,
Sir, you may share your presentation.
Yeah. So I hope this is visible.
Yes, absolutely, sir. It is visible.
Okay. So many thanks to Professor Avinash earlier. He actually made fellow speakers' job a bit easier because now all of you have got an idea about the way IB actually works in a real business environment. So nobody is innovating for themselves unless there is a commercial value to it. Somebody asked about how do you actually put a monetary figure to a technology or a particular invention. So like sir said, it is complex, but there are ways to actually define and arrive at a price point. So my topic, and in fact, it is good that today actually we are discussing this patenting process, the whole prosecution of a patent application right from the inception of an idea. Because I think it's important as a science student or even a technology student that you understand not only the importance of IP, but also the value it produces in terms of innovation, and it incentivizes people to actually put in efforts in terms of money, in terms of time, in bringing new innovation to the society. In fact, this is the cover of an article I was going through just before the lockdown started. And I believe many of us would not have even heard of coronavirus before this particular lockdown. And this article actually talks about this development at least 6 years ago. So you see, it says scientists were close to a coronavirus vaccine years ago. Now the whole world is actually looking for a corona vaccine, and people are ready. I mean, the moment Russia announced that they have a ready vaccine, at least 20 countries have actually pre-ordered and pre-booked their vaccine quota with Russia, and it amounts to billions of dollars. So the point is to have people motivated to invent something new, innovate something new. You need to develop certain systems. I'm not talking only of patents, but it could be anything. So just ask yourself, if let us say you are a leader, you are leading a country, and you want that world's best minds come to you, and your people are motivated enough to invest in research and development from which the innovation would come. So what would you give them? You cannot give them endless supply of money because eventually you will run out of money. So how do you incentivize? So this was a system developed to actually incentivize people to innovate. So if I give you a single justification for having a patent system in any country in the world is to ensure that people constantly innovate. So like I asked you, how do you ensure that efforts to bring innovative technologies continue to be incentivized and rewarded? So you develop certain systems. So this is one of those incentives. So what is a patent, and what are the intricacies involved in the patent system? We will have a quick background of the patent law, look at the history of development, and fundamentals of patent law. Basically, the topic is a bit complex to be covered in I would say an hour-long session, but we will try to capture major thoughts in terms of certain case studies also, so that you take the important points about practicing patent law, especially in an academic setting, because I understand most of our participants are from academia, maybe students also, faculty members. So we will try to capture cases more relevant to this particular genre. So when we talk about patents, you understand that this is more of a law than science. And when I say that, I actually emphasize on the point that it has more to do with enforcement and protection rather than science and technology. Of course, science and technology are the bedrock for any innovation, but patent as such is a law. And when I talk about that, you can compare it with certain contractual laws. So this is for your understanding only, that when you order a home delivery of a pizza, so you kind of imply that if you deliver a pizza to my home, I will pay for it. So this is an implied contract. Similarly, if you board a bus or an auto or a taxi, you are implying that I will pay for this particular ride. Similarly, when you create a social media account or a Gmail account, you agree to the terms and conditions. Nobody goes reading those terms and conditions, but you actually agree when you click on yes, 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 and then move on the next. So these are all agreements. So if I say patent is also an agreement, then you should understand between whom. So what is a patent? Patent is basically an agreement with the state. When I say state, state is the government. So this implies that a patent is granted by a statutory body. So if you are applying for a patent in America, the US government will be granting you a patent. If you are applying in India, the Indian government will be granting you a patent. But for what? So how does, on what parameters the government will give you a patent, and what exactly is meant by grant of a patent? So when somebody is granting you a patent, what is meant by that particular phrase? So when I say patents are granted, it means that you are granted certain rights. For example, when you graduate as an engineer, you are granted certain right. Now you can consult on topics which involve engineering background. So patents are certain rights which the state offers you or the government offers you for what? For an invention. Now we'll study what is an invention as per the law. What are the criteria that yes, your particular idea is actually eligible for a patent protection. So it grants certain rights for that particular invention. But what does government want? So if government is granting you something, they want something in return. So what is that in return thing? That in return thing is full and complete disclosure of the invention. That's it. So this is a very, I would say, the crux of the whole patent system. What is a patent? The certain rights. Who grants it? The state grants it. For what? For an invention. Against what? Against the complete and full disclosure of your invention. Now this disclosure should be good enough for people in your field to practice it. For example, let us say if Edison today wants to have a patent on electric lamp, he should write it in a way that any fellow can practice that can make an electric lamp after reading that particular disclosure. If that disclosure is enabling enough, you will get a patent. Of course, that particular invention should be new and non-obvious, that we will study. So what constitutes an invention? So like I told you, patent is a contract between the state and the inventor, and since it's a contract, it is legally enforceable. So the government says that, okay, since you have for the first time brought an invention into the world, we are granting you certain rights, and if anybody infringes your right, you can come to me and ask for remedy for it. What is that remedy? It could be an injunction, it could be damages, it could be anything. The court would grant those kind of remedies. So this is a statement from the Lordships of Privy Council before India's independence. I mean, this is taken from the UK code, which is basically the foundation of the modern patent law. So invention is basically finding out something which has not been found out by other people. To put it as simple as that. So you have uh, brought in something new. Now that newness need not be complex. So many a time students confuse newness with complexity. I have an idea, but oh, it's so simple idea, I cannot get a patent on it. So you will see that even simple ideas can get patents. So complexity is not a measure for either a grant or refusal of a patent. In fact, they went on to say that there are many instances in various branches of science of independent investigators making the same discovery. That does not prevent the one who applies and gets a patent from having a good patent. For a patent represents quid pro quo. So this is a phrase we keep on using in our patent practice. Quid pro quo is basically in return of something. So quid is to the patent is monopoly. So what does the patentee get? Like Dr. Avinash also mentioned in the previous uh, session. So you are getting an exclusivity. Take for example, you have a huge campus, and let us say there are 10,000 students in your campus, and the administration decides that they will have a fast food restaurant in the campus. Now whoever opens that particular restaurant in the campus will have a kind of exclusivity. So all those 2,000 students will have uh, this fast food center within the campus, and nobody else outside the campus can sell it within the campus. So this is a kind of monopoly. So this is something, why big brands charge for franchisees. So if you're looking uh, for example, McDonald's joint in your campus, so that's a kind of monopoly. Nobody else would be able to sell it with that particular name. And what is the co is what you give in the return. It presents to the public the knowledge which they have got. So whatever you have developed, whatever you have invented, you tell it to the world in a manner that anybody after your patent is expired would be able to practice it. Let us look at the history and development of how it actually developed to the current system. So I was going through this history of patent law, and not many scholars have actually ascribed to this particular incident, but I have actually taken so that it gives you an idea of how old the patent system is actually. So we have written records for something, some kind of exclusivity for some kind of newfangled loaf of bread. So you can say this was one of the earliest patents, you would say, around 600 BC. So quite an old system, almost 2,500 years old system. And then eventually you have some shape of modern patent law. So in 1421, somebody developed a crane system for shipping and transporting marble from the Carrara Mountains, and this was awarded to Filippo Brunelleschi from Florence. Eventually, we had monopoly rights by King Henry VI on producing stained glass. So this was a technique which was not known in England. Now, you see, this is how it developed. Earlier, if you are bringing something new to a country, then the country would award you a patent. For example, let us say you go to US and you saw some amazing robot or some new device, and you're pretty sure that nothing of that sort exists in India. You come to India, you file a patent on that, you will get a patent under this particular regime because you are the first one in India to bring that invention in India, right? Eventually, it developed to a system wherein you have to be first in the whole world, not just a particular country. We will see that. Okay, then we have 1474, and this is something which most of the scholars agree that this is the foundation of modern patent law. In fact, this particular statute, the Venetian statute, had all the contours of modern patent law, which means that uh, it's kind of codified what would be required so that you have a patent, which means that it should have novelty aspect in that, and there would be an examination procedures. Only then you will be granted a patent. Then we have 1624, British Statute of Monopolies, and this is the foundation for Indian patent law as well. In 1790, we had first Patent Act of the US, and this actually paved the way for industrial revolution in US, and everybody was actually going for patents for as simplest ideas. So if you talk about patent law in India, so the very first legislation or law you can say was uh, drafted as exclusive privileges for the encouragement of inventions of new manufacturers for 14 years. So this was enacted on 28th February 1856. And you see, on 3rd March, so within 3 days, somebody in India, a civil engineer, so George Alfred Deppening, he was in Calcutta. So he filed a petition for grant of exclusive privileges under this act. So the government introduces an act, and within 3 days, somebody actually applies for it. And that invention was actually an efficient pankha pulling machine. So an efficient way of basically having a fan worked. So this petition was the first to be filed and was officially numbered as number 1 of 1856. The very first patent in India, you can say, was this one. But I mean, eventually this particular act lapsed, and government actually introduced some other act. So eventually it developed, and major patent act was this 1911 Act of Indian Patents and Designs Act, which had some characteristics of today's patent law. And then after independence, after so many uh, committees set up to see the working of patent law and whether it is actually helping our domestic industry or not, so many suggestions were brought in. So in fact, there was a committee under Justice Bakshi Tekchand, and they actually said that this is not actually helping Indian companies. And also Justice Rajgopal Iyengar committee also said that in fact we should not grant patents to products, we should only grant patents to processes, so that Indian manufacturers are able to manufacture a particular product, because the product is not patented, only the processes. Just think of it as, let us say there is a compound and it is patented. If a country has a regime wherein patents are granted for products, then nobody in that country would be able to manufacture the product because there is a product patent. But India chose that no, we will not grant patent to products. Here, you cannot get a patent on product. What does that mean? That if you have developed a product, then only the process by which you have developed the product, or the process by which the product could be manufactured, that only could be patented. So what Indian manufacturers did, they innovated. They tried to develop alternate ways of manufacturing it, so that they would not infringe the patent and still could come up with the product. So this was till 2005, and in 1995 we signed TRIPS, and we agreed that okay, to harmonize the patent law across the world, we will also start granting product patent, but we need 10 years. So eventually we started granting patents from 2005. So this was a brief history of Indian patent law. So let us look at worldwide IP filings, just to give you a hint of where do we stand today in terms of patent file. So basically, measure of innovation in a particular country. So there are certain bodies. Most famous is the WIPO, World Intellectual Property Organization. So they take parameters and actual real numbers of IP applications filed, be it patents, models, trademarks, or designs, to measure the innovation index of a country. So you see, this is the last year released numbers. It was released in August 2019. So it gives you an idea of how many patents are filed worldwide. So 3.3 million patent applications were received by different patent offices. So 33 lakh applications you can see. So who is filing what? So this is interesting because you see the huge difference between the number of filings. So as you can see, China is the top patent office and it receives annually, the Chinese patent office receives 15 lakh patent applications a year. And almost a third is received by US patent office. And then if you see India's number, I mean, it has grown in the last couple of years to around 80,000 to around 1 lakh, but still quite less when you compare it with the China patent application numbers. Now, this is an interesting slide or the data it projects. So these are different fields. So if you want to see which country is actually innovating in what particular domains. So you see, if you see the top technical domains contributing most number of patent applications, let us say in China. So these are computer technology, electrical machinery, apparatus and energy, and measurement. So these three constitute the majority of patent applications for China. When it comes to Germany, the number one, most of the applications are filed in transport. And it is, I mean, it's quite obvious. One of the strongest industries in Germany is the transport or vehicle industry. So you see all the BMWs and Mercedes, they continue to file number of patents. Similarly, for Japan, most of the applications are filed in optics and computer technology again. Whereas US, and it is not surprising because US leads in medical technologies. So the three main technology areas are digital communication, computer technology, and medical technology. So this gives you an idea of where the particular country is actually putting their research efforts in. And again, this is also a picture of most of the applications filed in a particular domain by these countries. These are all the top 5 patent offices which receive most of the patent applications in a year. So now coming to the life cycle of a patent. So since it's a live session, so you continue to post your queries in the chat box. We will take that maybe after the session. So this is the usual happening when an idea gets converted into a successful product. So basically, let us say you're working in a particular field, or you are using a particular product, you face a problem. For example, we all were using Skype, right, or GoToMeeting for doing these kind of webinars and seminars online before Zoom came in. So what was so unique about Zoom, if I ask you, that everybody is now using Zoom for organizing these webinars and these kind of online classes? One thing was, you don't have to install third-party applications. Now you just click on the link and then you are in. Now compare it with, let us say, GoToMeeting, wherein you have to have this browser plugin installed in your browser so that you are able to access the particular webinar. The point is, even if you are making it simpler, you have an innovation. So whatever problems you are facing, whenever you are facing a problem, try to find out solution. In fact, most of the patents are actually filed on problem solution approach. We have this thing called problem solution approach, wherein when you define your invention, you identify the problem first and you see the available methods to solve that particular problem and why none of them succeeded, and then you present your particular solution. So basically, you face a problem, then you start looking for solution. Now there could be solutions. So it's not that before Zoom there was no way of communicating online or having an online conference or online seminar or online class. There were, in fact, there were more than hundreds of applications which were doing exactly the same activity, but it was only Zoom which actually made some money. I think Zoom is now a $60 billion company, and this is the worth they have actually achieved within the last 8 months. So it's phenomenal. So you see, solutions, even if they are existing, but if they don't make you happy, right? Or they are not good enough for you. You can make it better. That betterment can be an innovation which will give you a patent. So you take matters in your own hands, you find a solution. Solution could be a flop, it could be a hit. Somebody might not like your solution and improve upon it. And this is the cycle of innovation which continues. So this is how typically an innovation cycle appears. So somebody identifies a problem, looks for a solution, then there is a research and development, and this gives you some leads. Then you start prototyping and start reducing that particular idea to practice, and then you launch it. Then people give you feedback, no, it's not good, or it's very good, but still you can have this improvement. You keep on doing it. Now parallelly, what happens to the patent procedure? So not after you have actually developed your idea, but the moment you have started thinking about your idea, start searching for available solutions. Now this will come in very handy when you are discussing your idea with your patent attorney. So what I mean, in technical parlance, we call it a prior art search. You don't need to, I mean, bother about these terms. Just look for what parallel solutions exist. So if I'm talking about, let us say you come to me and say, okay, I have this particular software written for enabling mass communication over online, wherein video communication and these kind of capabilities would be there. You should tell me that these capabilities already exist, but in, let us say, different forms, and this is how I have improved upon it. So you come up prepared to an attorney. In fact, most of the jurisdictions, and especially US, you are charged by the attorney for their time. So if you are coming prepared, you will save a lot of money in terms of attorney's time. So start conducting prior art search, basically looking for similar kind of solutions. Then you sit with your attorney and draft a patent application. Now this is again a complete different skill set in itself. In fact, in the last part of my this session, I will talk about some career options for you as in the patent professional. It could be an agent, you can be an examiner also. So you draft the complete application. Now there are different stages, but majorly there are 3 stages. You file your application gets published, then it gets examined. You talk to the examiner, you submit your answers to the objections, and then eventually your patent is either granted or refused. Once it is granted, you start paying for maintenance. So this is the complete life cycle of a patent application, and of course, the idea becoming a successful product. This is again another view of how it actually happens. So you come up with an idea, you do research on that particular idea. There would be certain failures. You start with almost 20-30 leads. You shortlist one of them. Then again, you try to prototype and develop it. Then you share it with your friends and your circle and take the feedback whether it is working or not. If the feedback is good, you take it to the production, and like sir said, you can either license it or take the onus of manufacturing and production on your own. So this is a very brief of what happens at the patent office. So you start with an idea. If your idea is matured enough so that you have clear route of how you are going to practice your idea, how you are going to reduce your idea into an actual product, you can file a provisional application. What does that mean? It means that you're not ready today with actual invention, but you have fair idea of how you are going to do it, and you have done certain preliminary studies and preliminary findings wherein you have clearly established that yet it would work, and these are the contours of your invention. So basic broad line of what you are going to achieve with your invention, and by this you are actually protecting the date. Eventually I will discuss what are the criteria for patentability. There you will see that whoever comes first and files first has the advantage. So you have to rush to the patent office. So like I said, many people might come up with the same idea, but patent will be granted to the one who has applied for a patent first. So provisional application is basically you are not ready with the complete product, but you still have the information about how to go for it ready with you. You file a provisional application. You have 12 months, so almost a year for you to take it to actually practice and come up with a complete application. Complete application will have uh, established elements of the boundaries of your invention. Where does the invention start? Where does it stop? What exactly is your invention? You will have certain data to back your claim. If you are saying that, okay, my improved engine is now 15% more efficient, so that now you have that data to prove that particular claim. So once you have that kind of things ready, you can file a complete application. Eventually your application is published. After filing, there are two ways of doing it. You pay for this publication or you get it for free. Of course, if you want it for free, you have to wait, and if you want it published sooner, you need to pay a fee. Then after publication, there is an examination. So what is an examination? Basically, patent office will look for whether it is actually new, whether your invention and your application conforms to the law, what are the requirements of patent grant in India, and they will uh, issue you a report. That report is basically a letter of objections why you should not be granted a patent. You receive that letter, and with your attorney or on your own, you write response to those objections, and after considering that, the patent office will either grant or refuse it. Of course, if it is granted, you pay for the maintenance fee for the patent, and the real battle starts after the grant of patent. That if somebody infringes your patent, that means that without your authorization somebody is using your technology or your invention, then you need to go to the courts, go to the police and tell that my idea is being infringed, my invention is being infringed, please help me. So they would help you because you have a patent certificate, you have a granted patent, and the court might decide to grant you an invention, which basically means that nobody would be able to use your invention without your authorization. Now in this, it doesn't matter how big or how small you are, right? I know a very small startup, they had this patent granted in India on credit card payment. So they improved the processing of credit card and other e-payments, and a big company was using that particular technology for their credit card processing. So this small startup sued them and got an injunction against the big company. So the point is, if you have a patent, you can fight with a big company or an established organization as well. So from an inventor's perspective, so you come up with an idea. So basically what would happen, you will start talking to the patent agent or patent attorney, or basically if you are in a university or an academic setting, if you have a tech transfer office or an IP cell, so your first point of contact would be a person in charge of that particular IP cell. Talk to them what next steps you should take. So basically you share your idea, you tell them what is your approach or what was the problem and what is your approach to finding a solution, whether you have done any searches. If not, they will do that on your behalf. Then eventually your patent application will be drafted and filed with your signatures as inventor, and based on the policy of your organization, you might be named as an applicant or might not be. Then you continue work on your invention and try to complete your invention within a year, and then come up with a complete application. Of course, everything is happening under the supervision of patent attorney, registered patent agent, who would advise you time to time what is the next deadline due, because every step in the whole patent prosecution is time bound. So you cannot say, okay, I want more time to actually develop my idea. Of course you can, there are ways to do it, but you will eventually let off of certain period, which was very crucial to secure the first date of invention, which is the priority date. Again, because of the time constraints, I'm not going deeper into that. Let us look at what is the governing law for grant or refusal of a patent in India. So the governing law is Indian Patent Act, as amended from time to time. In fact, these rules keep on amending from time to time. Very recently, also we saw some amendments in 2019 as well. So online, this act is available. Act and rules both. So you can go through these links. So majorly the Patent Act has 24 chapters. Different chapters constitute different scenarios. What would happen before the patent office or the appeals before after the patent office. All these things are there. Who can practice or who can advise you on patent matters? So not everyone can advise you. Like Dr. Avinash said that you have to have that kind of technical knowledge so that you can advise. So if let us say some electronics engineer coming to you, but you don't understand circuitry and all these architecture, you won't be able to help in drafting a particular application. So you have to be uh, conversant with that kind of technology. So you should be able to understand that technology so that you are able to help it. In fact, if you go to the other jurisdictions like US and Europe, the patent attorneys are seasoned professionals in their particular domain. You will find PhDs and postdocs with almost 15-20 years of industry experience in that particular domain, now coming back to practice patent law. So they are actually well versed with the technology, and they can guide you and help you in a much better manner to get a patent on that particular aspect of technology. So coming to the definitions, very important part. So when I say that the state will grant you a monopoly on your invention, so what is an invention? So our act says that invention means a new product or process. So I have highlighted the term new. What is new? Which is not known before. And that involves an inventive step. Again, very important inventive step, and capable of industrial application. Now, if you come up with an idea which cannot be applied in an industry, it is not patentable idea. Similarly, if you have got something which is already known, you cannot get a patent on it. So inventive step is a feature of an invention that involves technical advance as compared to the existing knowledge, or it has economic significance. Now, to put it in a simpler manner, economic significance would mean even if you are able to bring the cost down, it still qualifies for a patentable invention. Also, very important, and this will come up again and again when you are doing patent practice, something which is not obvious to a person skilled in the art, right? So for example, if somebody has said that you can use tungsten as a filament for electric lamp. Now you look at the periodic table and see what are the elements which will have the same properties as tungsten. So let us say molybdenum or any other metal for that matter has got similar properties in terms of resistance, melting point, and other things. And if you replace that particular filament metal with your metal, it is not a patentable invention, because uh, any person who is actually studying these metals would be able to replace tungsten with that kind of metal. The point is, your invention need not should not only be novel but also be not obvious. In India, we call it inventive step. In US, we call it not obvious. So this is a very important criteria when you are actually assessing whether your idea is patentable or not. So discuss this with your agent in the beginning, because if you come across prior art, which means certain documents which tell about your invention, or basically even if they are not telling exactly what you have done, but anybody would be able to come to your invention by reading those particular documents, then you might eventually feel that this is obvious. If you actually feel that and your attorney agrees with you, you can drop filing a patent application, because it's a costly affair, and you can save a lot of money by deciding early on whether you want to prosecute your patent application or not, right? Then we have new invention. As the name implies, new means new for the whole world. So like I told you in the beginning, even if it was known in a particular territory, if you let us say go to an exhibition in China and see some device, and you come to India and then develop that device and file a patent application, the patent office will search for available devices, and they will come across documents. Now, documents can be brochure, that or that pamphlet which you saw in the exhibition. If they come across that pamphlet or any online depiction of that, in fact, recently I have come across one YouTube video link. So somebody had posted a video link, YouTube video of their invention, and that was cited by the patent office. And many of the inventors actually do that, especially students. So they are so overwhelmed by their idea, by their invention, that they start posting on social media, Twitter or Instagram or YouTube, and that particular uh, invention, you are creating prior arts for that invention. So basically killing the possibility of you getting a patent by posting these kind of disclosures on social media. In fact, if you don't want a patent, then the story is different. You can go ahead and post it on any medium. But if you actually want and serious about getting a patent protection, please discuss all these steps before even participating in a conference or exhibiting your particular prototype or product in a scientific conference or workshop, so that your idea is protected. Capable of industrial application, like I told you, your invention should be capable of being made or applied in an industry, right? So when we are testing this not obvious, we are also using a term called person skilled in the art. So person skilled in the art is a person who is expected to know everything in your field. So he knows state of the art, he knows what exists before. If today an electrical engineer is devising new batteries or developing new batteries, then a skilled person in the art knows everything about batteries. So he knows what kind of batteries exist, what kind of technology exists in this particular domain, and he's a hypothetical, person who is expected to know each and everything about that particular domain. So you have to test your invention from the perspective of this particular person. If you see that that particular person would feel that your invention is not obvious, then you can get a patent. So this is one of the ways of explaining what is the difference between a novelty and inventive steps, the two major criteria of you getting a patent. When I say novelty, it's an absolute thing. Nothing is known about your invention. So no publication exists, whether it is in brochure or a written book form or any article, scientific literature, or published patent application. So patent itself is a rich source of information. So prior patents are also prior arts. So in fact, even if you don't get patent granted, your application by way of publication has become an important prior art in the particular domain. So the criteria is invention should not be published in India or elsewhere. It should not be in prior public knowledge or prior public use within India, or claimed or described before in any patent specification in India. So this is the novelty criteria. In fact, if we just see the first one, published in India or elsewhere, that elsewhere includes the whole world. So even if there is a publication in, let us say, a remote corner of Fiji or something, wherein you don't read literature from that particular region, still you are expected to know about the existence of that article. And if that kills your novelty, you won't be granted a patent. Even if you are able to get grant, anybody could challenge it, that before you applied for a patent, some article existed which told about your invention, so that your patent should be revoked. Now, what is an inventive step? So this is a feature of invention which will involve technical advance. So basically something is existing, but there is an improvement, there is a technical advancement to that particular existing knowledge, or it has economic significance, or both, of course. So this particular advancement was not obvious to people who were working in that particular field. So this is important. This is not a test from the ordinary people, but from the perspective of people who are actually working in that particular field. So now we have read about the novelty and non-obviousness and other criteria. So let us just take on quick examples. So I have put in this particular example, and you can comment and post your comments in the chat box, the comments box. So here the example is Sanjay is a final year MTech mechanical engineering student in IIT Delhi. He has developed a new wheelchair which can be controlled by a smartphone device as part of his MTech work. He wants to file a patent, but his guide, Professor Ashutosh, is not interested in filing for patent, but wants to publish the development in a research journal. Eventually, of course, Professor Ashutosh also wants to get a patent, but he's more interested in getting it published in the research journal. So what would your advice be? So let us publish in the journal or file the patent application and then go for other avenues. Again, keep posting. So when you're writing your answer, just put scenario 1 and then your answer. Let us take another scenario. Here, Ravi Bhati is an engineer with TiCare Global. He has invented a system which regulates the traffic more efficiently. Now, here lies the, unique thing. He comes to you. You means if you are a practicing patent attorney or advisor on this particular matter, he comes to you on May 1, 2020 with his invention, and he wants to file a patent. And when you do this search, you come to know about a similar traffic management system which exists in Russia since 2017. However, the details about the working of the system are available only in Russian. So the language is Russian only. I mean, whatever information is available about the system is available only in Russian. Now you see, anybody who is in India would not be able to access this particular information. So what would your advice be? Whether Ravi Bhati would get a patent or not? Right? Again, write your response in the comments box by with scenario 2. Another example. Again, here Anand is a PhD student in Dr. Kilker's lab. He has completed his thesis and has placed the manuscript in the central library of the institute on, again, date is important, on February 12, 2020. Now, this is the manuscript only. This is the thesis, which is not catalogued yet. Since you are students, you have visited the central library or library of your institute, you would see every single book or every single, thing in the library is catalogued, right? But here, this particular manuscript was not catalogued. Now, several students have visited the library since February 12, 2020. Now, then government announced lockdown on April 1st. On May 12th, 2020, after the lockdown, he comes to you and to see if he can now file a patent application on the work contained in the thesis. Now, again, remember, Anand placed his thesis in the central library where anybody could visit. Now he's asking, can he file a patent? Except for the thesis, the work has not been published anywhere else. Now, this is important. Nowhere it has been published, but it was kept in the library. So what would your advice be? Yes, go ahead, or no, you cannot get a patent because you made it public by depositing it in the library. So that there is no novelty now, right? So these are three scenarios. Again, one more scenario. Mr. Shah attended, and I hope you are sitting with pencil and pen so that you are, because I'm going a little bit fast because of time constraints. Mr. Shah attended an international trade exhibition in China in December 2019. I think I already told you the answer to this. There he saw a novel machine which could prepare a pizza instantly. And in fact, this was a story on, I think, some news channel some days ago. So he brought the brochure of the machine, which did not explain the functioning of the machine. This is important. He only got the brochure of the machine, right? If you go to the trade exhibition, they will tell you, I mean, they will give you brochures and pamphlets of their products. So since he was this, technical bent of mind, he reverse engineered whatever he saw, and he developed a unique machine which did exactly what the machine in China did, which means it could prepare pizzas instantly, right? So he did his own R&D, and he was able to come up with a similar machine with exact same function. He wants to file a patent on the machine in India. Again, what would your advice be? So write down your responses to all the scenarios, and I would appreciate if you can put in your logic behind that. For example, if you're saying, okay, in scenario 3, what was scenario 3? Yeah, Anand should get a patent, then why he should? Because the objection would be the information was already in public because he kept the thesis in library. So why should he get a patent? Because the very first criteria for getting you a patent is novelty. The moment he has put the thesis in library, he has destroyed the novelty. Or if you're writing answer for scenario 2, we should tell why should Ravi Bhati get a patent when this system already existed in Russia? If your logic is no, he should not get, then again, why he should not? Because he's the first one in India, right? So I will leave you with this for 5 minutes, and then we start discussing. If you want me to be on a particular screen, let me know in the comments. I am going through the comments. Uh, so if you want a particular scenario to be before you, let me know. I will put the slide there. Yeah. So I will keep for 10-15 seconds for each scenario so that you can have a look at the scenario. So please limit yourself to answering these scenarios and don't post your queries here, because otherwise it will be very difficult for me to actually go through your responses. I will take the questions in the end. And this is the fourth scenario. Okay, so great answers, but I was looking for logic actually. So just responded yes or no. Okay, so Neha has actually responded no. For scenario 4, let me take from scenario 1. So I'm only discussing responses where you have given the justification so that it is helpful for others also. Oh, there are so many comments, it's a bit difficult for me to actually go through all of them. So Kajal says in research journal, he will get the copyright protection. So again, different matter altogether. Please limit yourself to the current topic. So Ronnie Jenny says scenario 1. Let me go to scenario 1. Yeah, he should not publish if he eventually is looking for a patent. I think everybody would agree with this, not to be published in journal. So what happens in the academic scenario is everybody is looking for publication, right? So in fact, there are deadlines and you have to meet certain criteria of your own organization, where the organization is looking for your number of publications. But the point is, if you are actually looking for grant of patents, you should seriously look for filing a patent application first. The reason being, the moment you publish it, right, the day on which you have published it or the day on which it is published becomes the day for prior art, which means that, let us say today, if you have published, then nobody after today's date would be able to get a patent on that same information, on that same invention. But let us say if you have filed a patent application, be it provisional patent application, so today's date is secured. So whatever happens after today will have zero impact on today's activity, which means that if today you have filed a patent application, then if tomorrow somebody has come up with the same idea and he publishes it, or he puts it on YouTube or any other medium, or he files a patent application, those things will have no bearing on your application because you have filed it first. So rightly answered. I think everybody has answered this scenario 1 correctly. Now scenario 2. So research, Vishwajit Singh said research paper. I don't know what do you mean by research paper. Scenario 2, Saiketundu Debroy says publish the work. I think you're confusing with the scenario 1. So scenario 2, I'm again repeating. So here, what I wanted to highlight was, it does not matter in what language, in what region the information exists. As a patent examiner, our patent office or any patent office, or I would say some good patent offices, they would have access to the journals in every language. At least theoretically. So they are expected to read journals which are published in German, which are published in French, which are published in Spanish, which are published in English, which are published in even Sanskrit. So if there is a journal quite famous for, let us say, publishing something for, let us say, cancer research, so as a patent examiner, you are expected to search for advancement in cancer research in those journals. So if something existed in Russia, even if it was in Russian, the very fact that the system existed deprives any fellow inventor of getting a patent on the same technology. So the point here is, it does not matter if the information or the invention was available in a different language. And this is something, today's inventor should be very, very careful about. What we usually do, we do Google search. Now, Google has its own limitation of giving you search results. In fact, I also do quite a number of searches on Google platform also, and other paid databases also. The most important limitation I've seen is the language search. And in fact, most of the patent applications which are published in China are in Chinese, similarly in South Korea in Korean, in Japanese patent applications. So these search engines are not made or not kind of enabled to search for text in those languages. For example, if you're looking for touchscreen devices, so that would have a different meaning in different languages. The point here is, you should be able to select a particular platform for searches, conducting your searches, which guides you and takes into account the terms, the key terms, the search terms, which also appear in different languages. Right? So one system is there to help you in this, which is called International Classification System. Again, I'm not going into that due to time constraints. So I hope this is clear. Scenario 2, language does not matter, region does not matter. Scenario 3. So scenario 2, I think Sabarnika rightly said, shouldn't go for a patent. Mahima, no, he cannot get a patent because it is already there. So Ronit says, I will ask him to stop investing his time in the patents. It's already been published somewhere else. Yes, very good. Vishal also says, I think, okay, Vishal says, since it's only available in Russia, it can be implemented in India. Vishal, if you see, we discussed, it does not matter in which country it was there. The very fact that some information was already there or the invention already existed deprives any fellow one of getting a patent on that again. Okay, now jumping to scenario 3. I'm sorry, I'm not reading all the comments. Scenario 3, which says, go ahead. I was looking for justification. Again, go ahead. So no justification there. So Ronit says again, scenario 3, no, you made it public by depositing it in library. So now this is interesting. This is an actual case which happened in US. So what, see, the patent law expects a patent examiner or a scientist or an inventor to do a due diligence, right? So let us say, if I am looking for a prior art document or any document related to my research or my invention, so what will I do? I will look for scientific journals. I will look for some texts, renowned articles, or I will do Google searches, Google Scholar or PubMed or Science Direct, or all these basically databases, and also go for patent literature searches on patent databases and other tools. Now, let us say this library was on my radar and I was looking for the particular manuscript. But do you think there was a way by which I could have arrived at that particular thesis? Because this is not cataloged yet. This particular point not being cataloged is very important. Why? Because let us say, if I am doing my due diligence to arrive at all the literature which talk about my invention or which are related to my invention, I will never come across this, because the library will never throw me the result, or even if I am actually physically present in the library, and if I'm doing due diligence and I'm doing the search to come to this particular manuscript, I won't be able to, because this is a non-cataloged item, which means that I might accidentally come across this particular manuscript and I might accidentally read it, but this does not mean that this is a valid prior art, right? So there are certain limitations to what constitutes a valid prior art. If you are sharing with your parents or your brothers, sisters, your invention idea, this is a kind of limited circle. This is not constituting publication. Similarly, if you are only writing to the editorial board about your future publication, your article, this will not constitute publication. So there should be enough number of availability of your work, and it should be available through due diligence, not accidentally. So here, since it was not cataloged, it won't be constituting prior art. So you can go ahead and file a patent application. So scenario 3, we have a yes. Yes, you can. Now, scenario 4. So Dr. Shamsher Singh has said scenario 3, go ahead, but I was looking for reasons. So many of you have said no, 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 but I hope now it is clear why it is yes. So Anvesha again says go ahead, but again, no reason given. Mr. Debroy says no, not to go for a patent, but again, reasons. Okay, so we are going beyond time. So let me just quickly address this fourth one. Again, you have saying yes, he can, but yes and no. Please try to give justification. So again, Ronit has given answer here again. He cannot and should not file a patent since someone has already made that machine. Very right. I think this was very clear. If you look at the scenario 1 also. So it does not matter if precisely something is given in written form. If something is existing, right? If something was available for sale, that particular fact that something was available for sale is a proof that something existed before your invention. As simple as that. So no, you cannot get a patent because the same product existed earlier. Of course, now let us say, since you have done your own R&D and come up with a similar kind of machine, there might be some more invention, some more innovation, some on some aspect of your machine. So that you can discuss with your attorney, right? So if you look at, I mean, the broader perspective, the point was, if you have just taken a look at a brochure and then developed independently a machine, you might have done some innovation, but the very fact that the machine existed before you bringing up with your product, you might not get a patent on it. Okay, so I hope this is clear. Now let us look at patent application. So what is actually a patent application? In the beginning, I told you that it is more of a legal document than a scientific document. So homework for you today, read at least one patent application of any area of your interest. I mean, choose a company. If you're, let us say, a fan of Google or YouTube, just I will give you some links for databases. In the assignee name or the applicant name, just put Google and look for patent applications filed by that. Tesla is a very good example. They are filing a lot of patents on technologies to improve, batteries and all. Or Apple, I mean, the only company in the whole world to reach $2 trillion valuation. So look for, this would be interesting exercise for you. Look for patent applications filed in the month of March 2022 till today. So there will be, not filed, published. So there is a time period under which every application remains a secret document. So if, okay, let me just go to the patent application. The patent application is a scientific as well as legal document, and it has a title which will give you an idea about what the invention is. It will talk about field. So what is the invention related to? Is it an automobile invention? It is a electronics, or it is a drug or medical device or a diagnostic device? So if you see during this coronavirus pandemic, you will see a huge surge on vaccines related to coronavirus, or vaccine candidates, antibodies, or diagnostic kits. In fact, India also developed a rapid diagnostic kits, which gives you results within 3 hours instead of 24 hours. So all these things are patentable inventions. then it will have background. So what existed before? So you give a brief of your technology area. You give a brief about, okay, people were looking for these kind of tools or these kind of solutions to this problem, and this is what they came up with. So you kind of build a story about your invention. Then you come up to your invention. What has you done? So you provide all the technical details. So this is more of a scientific writing. If you have written a scientific publication, you will see it is very much like writing a scientific article till you reach claims part. Claim is something which is, I would say, more legal than technical. If you are explaining your invention and drawings help, please include drawings. And in fact, I have never seen a mechanical invention, for example, without a drawing. So always include drawings and illustrations. Then detailed descriptions. Like I told you, if you're writing a complete application, you should back any claim you are making with data and other stuff. Now, so I told you in the beginning, complexity does not matter, right? So these are some examples of patents on paper clip. So if you see, one of the earliest patents on paper clip, I mean, it's very simple tool. Everybody every day uses this simple tool, and some of the very first patents were filed in US in early 1900s. So if you see, this is the patent granted in 1896, right? Then eventually there were certain improvements, and some patent were granted in 1900, and the improvements continued. And now this is a patent granted on March 15, 2016. Again, a paperclip. The point is, even if you are improving a simple tool, as simple as a paper clip, you can get a patent, provided you are able to prove the novelty and the non-obviousness or the inventiveness of your invention, right? So these are some of the features of a patent application. I hope this is visible. So there is a title, as you can see. Title says self-adjusting three-headed toothbrush. So like the title says, you understand that this is an invention about a toothbrush which has got three heads, and it is self-adjusting. So there might be some mechanism in this toothbrush by which the toothbrush can self-adjust. Obviously it would self-adjust according to maybe your jaw size, or maybe size of your teeth or something. Then very first is the US patent, which means that this is a US granted patent. So every patent is a territorial document, which means that a patent granted in US will only be enforceable in US. Similarly, if it is granted in India, only in India. Then there are other things there. Again, due to time constraint, I'm not going deeper into this. Again, coming to the search, it is, I mean, I don't know why today we are not doing enough patent searches. Whenever you are doing any project or anything, patent search should be the first thing you should do. In fact, there was a peer-reviewed article which said that patents are a rich repertoire of scientific and technical information, and more than 50% patent information is reproducible. Reproducible means that they are correct information. In fact, legally, you are required to tell in your patent application things which can be replicated, which can be reproduced. If somebody is not able to reproduce it, you can actually challenge that patent. You can actually revoke that patent. However, only 15 to 20% research papers have reproducible research. It simply means that people are just getting their researches published without actually, valid data. So patents are more reliable source of information rather than research papers. So please start doing patent searches. So these are some links. I will also post these in the comment box. So I think you can also Google these searches. This is the USPTO website, patft.uspto.gov. USPTO is the US Patent and Trademark Office. Then we have something called eSpaceNet. eSpaceNet is the European Patent Office website. Very good interface. In fact, one of my favorite interfaces when it comes to patent searches. There is a tool for simple search. You just put your idea there, and it will throw you results. No need to actually be skilled in this patent searching. So try it. Very helpful. In fact, there are very helpful menu buttons also, wherein they would help at each stage of searching. So if you're not able to put right term in the search box, they will help you out. Then we have Google Patents. Again, I would say it is work in progress. Hopefully they will improve a lot. but not that reliable, I would say. The patent scope, again, a good database. I hope you're writing these down because you can just Google it and you will come across these links. Okay, so go to these websites, and this is a 5-day workshop, and maybe on the 5th day you can let us know which one is the best, and you can rank all these patent databases. And the last one I have put in India's own Indian Patent Office database, IPRED.nic.in, and you look for InPass. This is what you are looking for, and look for patent applications. As an exercise, you can look for patent applications filed by your organization or a company you admire. If you, let us say, TCS is something you are looking for, you can look for all the patent applications filed by TCS or something like that. Now, if you've done the patent search, what next? Of course, the next step would be deciding on whether you want to file a patent or not. Of course, most of this will come from your searches done, and your organization would also see whether it makes business sense for you to actually patent it or not, and it is very important. Your policy defines what ideas will be taken up for patent application or not, because filing for patents, maintaining for patent, prosecuting a patent application is a costly affair. And I'm not talking about only India, but on a global scale. So it's a costly affair. So do your due diligence, justify. If you want to file a patent, you should know why you are filing a patent. What is the end term objective of filing a patent application? Like Dr. Avinash said in his previous presentation, you should evaluate, because eventually just filing and keeping your patent filed does not make sense unless you are helping the innovation reach public. So you should look for industrial partners who can take the information in your patent or your invention and actually build a product around it and bring it to the market. So all these things you should discuss with your administration and of course the management. So prosecuting a patent application, I think we don't have time for, because prosecution is basically how do you take your patent application through patent office. I will very briefly describe you. So this is the structure of patent office. So based on where you live, or basically where the invention has originated, you will file the application at the respective patent office. So we have basically 4 patent offices. So if you are living in any area in India, which is, yellow, so you will file in Delhi patent office. Similarly, if you are living in green, you will file in Bombay. If you are living in red, Chennai, and if you are living in gray, Kolkata. So these are 4 patent offices. So these are the territorial jurisdictions for all the patent offices. Sorry, I'm going a bit fast, but I hope this is clear. These are number of forms. These are all formal requirements. So you don't need to actually remember all these things. Once you are ready with your invention and patent application, you will eventually come across this information. It's readily available, and basically not knowing this will not hamper you from getting a patent. As soon as you log into the online platform of filing of Indian patent application, you will come across all this automatically. Right? All these forms serve a particular purpose. For example, if you are want to request for examining your patent application, you will file form 18. So all these things are there, and all these steps are time bound. Please remember, timing is very important. If you are not taking necessary steps within the time frame, you might lose your patent forever. Okay, so stage 1 is filing, and stage 2 is publication, like I told you, and stage 3 is the examination. So this is again a brief of what forms are required, what timelines are there. All these things you should be aware of. Then we come to international filing. Of course, if your invention is important enough for other territories, you should seriously consider filing your patent applications abroad. And there are certain timelines also. Most of the problems exist because of the budgetary constraints. Most of the institutes, especially government funded institutes, don't have enough budget to file patent applications outside India. So you should be very careful about which countries you are choosing. Sometimes less number of countries might give you more GDP or more captive consumers than filing in number of countries. So you have to be very judicious in which countries to file. Also, cost would be a factor. For example, if you're looking at Gulf countries, So I had an application where just the translation costs were hundreds of thousands of dollars, just the translation cost, because you had to get all the applications translated in Arabic, or similarly for Korean and Chinese applications. So you have to consider all these things before considering a particular country. Then there are routes, and your decision could also be based on size of the market. So you don't want to lose China, you don't want to lose America, you don't want to lose Europe, because these are very big markets. In fact, today I would say you don't want to lose Southeast Asian market, Indonesia, Thailand. These also constitute very important market for Indian manufacturers. So size of the market is very important. We are looking for where to file, and if there is a manufacturing center, so please be aware, if there is a manufacturing center, your product will be copied, and if you don't have a patent, you won't be able to do anything about it. So if that is why there is a huge number of patent applications filed in China, because everybody knows that if they don't have a patent in China, anybody would be able to manufacture it in China. The moment you have a patent in China, you can actually enforce your patent in China, and Chinese manufacturer won't be able to manufacture it because of your patent, right? All these things you should consider when you want to file it, and there are different routes. If time permits, and maybe during the workshop, if there is another session, I will discuss which scenario to take. So there are basically two scenarios: a Paris Convention and PCT route. I think somebody else is going to take international filing of PCT application. Then we come to IP management. I think you got fair idea about IP management in the previous session when sir discussed about transfer of technology. I think Dr. Sahu is also discussing tech transfer. So most of the IP management is centered about the goal of your organization, the business strategy of your organization. So every policy you make, every statement you make, or every decision you make about IP should be linked with the business strategy, your business goals. So if it is to capture a market, you have a different strategy. If it is to, for example, if you launch unbranded just contract manufacturing, it's a different strategy altogether. So basically see what kind of goal you want to achieve. If there is a huge push on innovation, and you are encouraging your employees and your scientists and management to file patent application on each and every idea conceived, so that's a different policy altogether. So the point is, everybody should know about the policy, IP policy of your organization. So not knowing should not be an excuse. So some faculty member not filing for patent application but publishing it and coming back to the management and saying I was not aware of this should not be an excuse. So try to develop that kind of culture wherein everybody knows about, especially with first year students coming in. So there should be a dedicated induction program for students and new faculty coming in, that this is the policy and you have to adhere with it. Even if you're writing an article on a online platform, this is what governs you writing or publishing something on a platform. If you're developing something in the labs, in the incubation centers of the institute, this is the policy which will govern the ownership of your product. So all these things should be clear to the employees and students. Then there are certain tips. So do due diligence, know about all these things, know about your rights, know about pitfalls. So what can hamper your patent application, what can seriously prejudice you getting a patent, all these things you should be aware of. So last part of this is the career, and please keep on posting your queries. I think we will have a couple of minutes to address all the queries. So there are two scenarios, major scenarios. You can be a part of professionals who practice patent law, which means that you can be an patent attorney or patent examiner. So basically, patent examiner would examine whether you should get a patent or not. A patent attorney would take the invention from the inventor and draft a patent application and produce it before the patent office and help you get a patent. Similarly, they will also help in enforcing a patent or defending your product. All these things can happen. And second is the analytics part, which means that all the searches, all the decision making or the management, all these things constitutes more of informatics and decision sciences. So based upon your passion, if you are more into data analytics and all these things, you can consider a career as a patent analyst. Or if you are more into legal acumen or drafting, then you can consider career in as a patent attorney. How do you make a career? So there is an examination conducted by the Indian Patent Office, and eligibility is a science graduate or a technical graduate. So they conduct every year. Due to pandemic, this year's exam, which was supposed to happen in July, was postponed, and I don't think this would happen this year. So keep on visiting Indian Patent Office website for next year's patent agent exam. Similarly, they also conduct patent examiners exam. I think it was taken only last year, so might not happen this year again. So patent examiner is a gazetted post, so you can apply for that. And every year, I think they take more than 200 to 400 examiners. So they will again, this will again give you an opportunity to make a career in the patent field. So thanks a lot for your time, and we can now take questions. Or Dr. Saurabh, if you're there, I think.
Yes. Yes, Mr. Sandeep Agarwal, sir.
Yeah.
Sir, thank you very much for your wonderful session on patent filing procedure and prior art search. You have wonderfully created basically you have dealt with all these things with the criteria along with the case studies. You have managed the YouTube participants as well as you were taking the questions along with managing your session already. So, sir, I hope that you have taken all the relevant questions which have been posted in the comment section of our NIT Silchar official YouTube channel. So now, sir, we are closing for the day.
Okay.
I'm very thankful to you, sir, for taking
Thanks a lot
on this topic. Fine. Okay. Thank you very much, sir. Thanks a lot. Thanks for gracing in one day, in 5 days online workshop on intellectual property rights and entrepreneurship development. Thank you very much.
And best of wishes, best of luck for the future sessions. Thank you.
Thanks a lot, sir. Thank you. So this is where we have ended to the first day of this 5-day online workshop on intellectual property rights and entrepreneurship development. Information to the participants that tomorrow we will meet at 5 p.m. We will be having with us Professor Rajendra Kumar, Dean Student Welfare, NIT Silchar, and he will be talking NIT Kurukshetra, and he will be talking about the concepts, relevance, and forms of IPR, along with Dr. Sunil Kumar Yadav, Assistant Professor RDIS, and he will be talking about the international agreements on IPR. Till day, good evening, take care. Thanks to all the participants for joining. Thank you very much.